discussion?
Yes.
Yeah, I mean, if they've already put their notice of appearance in, if you confirmed it, they can probably waive your arraignment. This is really just for people that don't have the hearing. What's your name? I don't see your name on this copy. So you probably already have another court date. You can check with them still, and even though you have a private, they'll tell you on court date. With the two ladies in the side room over there.
What's your name? My tan.
Says Martin. I don't see his name here. That means he's probably represented. We're not gonna call this case.
Court will come to order, all rise. Circuit Court in Fulton County is now in session. Now with Judge and the counsel presiding.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Good morning. Please be seated. All right. Are we ready for arraignments?
Yes, Your Honor.
All right.
Starting with Judge Branning's docket, Dersu da Silva, 26 CF 000173. You can come up.
You applied for the public defender today and qualifies, Your Honor.
All right. Public defender's appointed.
This is for De Silva?
Yes.
Yes, Your Honor, we'll just enter a plea of not guilty, waive the formal reading of the charges, ask for a CMC.
All right.
And state filed information.
What's the next court date?
June 9th at 8:30 a.m. and 8B.
Did you get that? Did y'all hear your court date?
What was it again? Sorry, he was
June.
saying he needs a Brazilian Portuguese interpreter.
Oh.
I don't know if we have one today.
I know, that's why I was
Okay.
wanting to know his next court date. It was June 19th?
June 9th, 8:30.
All right. And then
Okay.
just make sure for that we have an interpreter for you.
Orlando Aguiar, 26 CF 015076. Orlando Aguiar.
Let's just roll that and keep going.
Okay. Moving on to Judge Kyle's docket. Jaden Maurice Pierce, 26 CF 000255.
He's in custody, Your Honor. He's a minor, but he did qualify on Friday.
All right. Public defender's appointed.
And the state filed in information.
Yes, Your Honor. We'll just enter a plea of not guilty, waive the formal reading at this time.
June 30th at 8:30 a.m. and 8A.
Okay. Antonio Miranda Fonte, 26 CF 015096. I believe he's approaching, Your Honor. The state filed in information.
Did he apply?
Oh, he is not the defendant. You said he did qualify?
I didn't see anything.
No. So the issue is this was a family member. He has been put into custody of ICE. So that's why he is not here today.
Hold on. That's okay.
State filed in information. Can we just roll the arraignment, Your Honor, so that we can look into his custody status?
Right. I mean, we don't know what that is, so we'll roll it for 1 week.
Yes, Your Honor.
It'll be May 11th at 8.
Needs to address, and do we have all the jurors? Do we have all the jurors?
They don't come till 10.
That's why we have them at 9. That's right. So we're doing the jury instructions.
Correct.
Okay. Very well. Ready?
Yes.
Okay. So do we have a clean packet for everybody? Where are we?
That was provided to you,
This is it?
yes.
Okay.
And the fence has had it since Thursday.
Okay. All right. So any significant changes, deletions, additions to the instructions?
Judge, we asked that this section be added to the principal instruction in reference to mere presence and mere knowledge not being sufficient to.
I'm sorry, can you get it by the microphone? I apologize.
Sorry, Judge. the defense has added language to the principal instruction that would indicate that mere presence and mere knowledge is not sufficient for conviction under the principal theory. I did supply the state with some case law, Judge, this weekend, albeit late last night, but I did send it to him this weekend, reference to that issue.
Okay. Do you have a printout or a copy of what it is you're asking?
Judge, I just want to make it clear, I got an email at 5:24 this morning with these proposals, and then as you were taking the bench, I saw their proposed instructions, so I haven't had a lot of time to look at it. What I have.
You just got it at 5:24 this
I did,
morning.
yes, Judge, with all the proposals, and again, we sent jury instructions a week ago Sunday. We sent them Thursday
Right.
night again, and the first communication with these changes and proposals was sent at 5:24 this morning. And as you were taking the bench, co-counsel Mr. Montoya came and showed me the proposed change. So I'm not very happy right now because it feels like a little bit of an ambush, especially given light that the court has multiple times throughout this trial instructed defense to communicate. However, I have had a chance to look over the law the defense cites, and I believe it's an accurate recitation of the law about the mere presence. So at this time, I'm not going to object. I have no
Okay.
reason, or I haven't had time to research, but it is an accurate recitation.
Okay. So let's go through the instructions. I'll read out the title of the instruction, and then Mr. Wheeler or Mr. Montoya, whoever's going to handle the jury instruction part of it, just let me know that you have no objection. Of course, if you have an objection, you can say it, but I'll read out the title, and then you tell me no objection, there's no objection. Everybody understand? If there's no objection. Does that make sense?
So to be clear, Judge, I indicate to Ms. Miller that anything past page 41, the defense was okay with exception to the verdict form. So it's just those first 40 or so pages.
Okay. Well, I'll go through each one. All right. Who's going to be doing the objection, no objection? Mr. Montoya? All right. And for the record, state's present, defense counsel, the defendant are present. Introduction to final instructions. Statement of charge.
Just to be clear, it's listed as first degree felony murder, correct? Or first degree murder?
Page 2 says Thomas Stein, the defendant in this case, has been accused of crimes of first degree murder and 3 counts of attempted robbery.
We just asked to add felony murder.
To the first degree felony murder?
Correct.
Okay. Any objection from the state?
Judge, I just may have a moment.
Okay.
Judge, the indictment is charged as first degree murder. I don't have a problem putting felony murder, but that is how it's charged in the indictment.
How does it read in the indictment? First degree.
Count 1, first degree murder, actual possession of a firearm on or about March 17, 2024 in Lee County, Florida, then unlawfully from a premeditated design to effect the death of a human being, or while engaged in the perpetration of or in the attempt to perpetuate a robbery with a deadly weapon, to with a firearm kill or murder Kayla Rincon-Miller.
Right, yeah.
So Judge, I think the defense and I did talk a while ago about when I provided the instructions last Sunday, that normally there's 2 ways to prove first degree murder, and there would be an instruction for premeditated first degree murder. That clearly, I don't think there was any evidence that showed it was premeditated, and so we did not include that instruction, and I think the defense is in agreement. If they're in agreement with that, I'm okay adding the first degree felony murder. But I just want to make sure they're okay that the premeditated part is taken out, because if not, then I think first degree murder would be appropriate.
All right. Mr. Montoya?
That's correct, Your Honor. I don't think there's any evidence to show premeditated murder, so we just asked throughout the entire instructions when it references to first degree murder, we just add first degree felony murder.
Okay.
That's fine, I have no objection to that.
Very well, then we'll make that change.
On page 2.
All right. And then introduction to homicide.
Same thing, Your Honor. Every time it references first degree, we just add that first
It'll
degree
be
felony murder. That's the
first
only-
degree and then add felony before murder.
Do that first line and that first paragraph.
Okay. All right. Any other objections?
No.
All right.
And Judge, I just would ask that the defense agrees that we won't include that premeditated instruction.
That's,
Do you agree with that?
we agree, yes.
Okay. All right, count one, first degree murder. I presume you want it first degree felony murder.
Correct, in the title, and then also the first paragraph, and then the bottom of the count one, include felony murder.
Yes, I see. Okay. Other than that, any other objections as to count one?
Count one, looks like robbery is defined, and then attempt is defined. And there should be the principal instructions.
With the addition that the state agreed to?
Correct. We stated, I'm not sure how it's written there, if it's written there at all, but however, mere knowledge that the underlying attempted robbery is being committed and mere presence at the scene is not sufficient to establish Thomas Stein as the principal to first degree murder.
Okay,
Felony murder, sorry, first degree felony murder.
all right.
And then subsequent to that is a paragraph in the bottom, again, add felony murder.
And Judge,
Independent, I'm sorry, go ahead.
the defense had requested, we had added, I sent them instructions as well as a court on Thursday with some highlighted blue, and it was added to the standard instruction about principles. The principles instruction does not apply to this finding. They do not want those added blue sections that are not part of the standard, so we would take that last sentence out on page 7.
The sentence reads what?
On page 7,
Mhm.
the last sentence, the principal's instruction does not apply to this finding.
Oh, okay, I see.
It's an accurate recitation of law, they just don't want it added into the standard, and that's fine, we'll remove it.
Okay. All right. Independent act.
As long as it says first degree felony murder, I think that's.
So yeah, everywhere, I'm sure we could probably do a find and replace. Everywhere it says first degree murder, just add in felony. But actually in independent act, it says first degree felony murder
Okay.
on my sheet.
Yes.
That's fine.
Okay. All right, aggravation of first degree murder by carrying, displaying, or using a firearm. Is that also where you want to add in the felony murder?
Yeah, no objection.
Okay, and then what about the principal's instruction in the second paragraph?
Same, we asked that that additional paragraph be included in the bottom. The mere presence, mere knowledge.
Right, but I'm asking about, it says the principal's instruction does not apply to this finding.
That's correct.
So take that out?
Sorry.
Okay,
Could I just,
yeah.
Mr. Montoya, could I get a copy of what you're proposing so that my trial assistant can add that in
Yeah.
for
You
principles?
don't have that.
You took it back.
My
The-
copy?
No, the special instruction you just handed me that you want us to add for principles. You came over with a patch, yeah. I just need
Do you have a
that.
copy for the court and for the state?
Nah, but I emailed them. I only printed one copy.
All right,
You didn't, this hasn't been emailed to us.
That has not.
No, it has not. You just gave it to me in court this morning.
okay. And you emailed the originals, these are the ones that I have in Word to the defense?
Yes, sir.
Okay, did you all do any corrections in Word to, you did?
I just sent the updated one with our cross-outs.
Okay,
Highlights.
great. Then that's for all the instructions?
Yes,
Okay, great. All right, so then possession of a firearm and discharge causing death?
Again, felony murder, and then we can remove the principal instruction does not apply, that's fine.
Okay, lesser included crimes?
Final sentence includes felony murder.
Okay. Count one, lesser included crime?
No changes.
Okay.
Just the felony murder.
Is that in there?
We have second-degree murder, right, so that's included.
Just on the second degree murder?
No, but it just says the lesser included crimes of first degree murder, so we'll just pop felony in there.
I didn't see first degree even written on that page.
It says the lesser included crimes of first degree murder, so I'm just saying
The
we
title.
would have to.
In the title?
No, at the bottom. Are you talking about lesser included crimes?
Page 11?
Page
Oh,
11.
I'm on 10 still. Okay, all right. What was the change in
None.
11?
It said
No
no.
change.
No
Page 11.
Okay.
Right, okay, I have to make sure we're literally on the same page. Okay. I'm on to page 12. Aggravation of second degree murder by carrying, displaying, or using a firearm.
Just remove the principal instruction does not apply.
Okay. Anything else?
On page 12, no, Your Honor.
All right, page 13, possession of firearm and discharge causing death.
Again, remove the principal instruction does not apply.
Anything else?
No, Your Honor. I would just ask that after each lesser included crime to count one, we include an independent act instruction.
Of each lesser included?
Correct.
Okay.
Before we move on to the manslaughter lesser included, we ask the independent act to also be listed there.
All right.
For second degree murder?
Correct.
Count one, lesser included crime manslaughter. This is on page 14. Any objections?
No objections, that's to page 14.
Okay. Page 15, aggravation of manslaughter by carrying, displaying, or using a firearm.
Again, remove the principal instruction does not apply.
Okay. Page 16, count two, robbery.
Before we move to count two, also another independent act instruction as to that manslaughter.
All right.
Independent act doesn't apply to manslaughter, I don't believe.
That's fine, Your Honor.
So not do the independent act after the manslaughter?
We're not going to use principal theory.
Okay.
We'll
This is why I wanted y'all to talk over the weekend, not at 5:30 in the morning today, but, all right. Take that out. Or not put that in, I guess, as far as independent act after manslaughter. Count two, robbery. Any objection?
It was charged as attempted robbery, so count two would first like to be listed as attempted robbery.
State.
I'm confused what he's asking.
He's saying it should be attempted robbery instead of robbery, because the way it's charged.
You guys first with the robbery elements.
I
just
understand.
asked attempted first.
Yeah, I think it's probably stylistic, but the way that the standard jury instructions are, you read robbery and then read the attempt, but, you know, it's,
You read robbery and then what?
you
And then-
read robbery and then afterwards you read the attempt to commit a crime, but I don't think there's anything wrong with doing attempt because that is how we charged it. It's just frustrating. Judge, the email at 5:24 this morning said pages, up to pages 41 were all accurate and good, so it's just catching me a little off guard if I just may have a moment.
I think it's the other way around, after page 41.
Right.
So let me just get this clear, Mr. Montoya. You want count 2 to say attempted robbery, none of the language would change, and then attempt would be defined afterward?
You want attempted robbery, basically invert it, how you had it. You had robbery and then attempted robbery. We want attempted robbery listed first, the elements there. And then define robbery. There's no objection how you define robbery.
So the attempt instruction is this.
It's separate, correct?
Right. So you wanting it incorporated into the robbery, or what? I'm confused what you're asking.
We'd like count 2 to read attempted robbery
Okay.
for Kayla Rincon-Miller, and the instructions read to prove Thomas Stein attempted to commit the crime of robbery. The statement to the following 3 elements. Go to the elements. The paragraph under the elements, the line between mere preparation and overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime.
So right now, you're just reading the attempted instruction. So you want this abandoned, you don't want any of this language, and you want it to say count 2 robbery, and then the language from attempt.
Count 2 attempted robbery. When you said this abandoned, is that the robbery definition? We can miss
Count
that.
2, page 16 has count 2 robbery, and then page, and it goes 16, 17, 18, and then 19 is the attempt. So you want 16, 17, 18 gone, and 19 would say count 2 attempted robbery?
Not gone. We want the attempted language to be listed first, and then the language that you have for the crime of robbery to be listed under.
Do you have an example of what you're asking for?
Yes. It's on page 60 of the statute.
Right. This doesn't define attempt though, that's an important. It's missing. No, it's not.
Giving it this one. So essentially, you will read like this. Include that.
Where's the letter suggesting that maybe?
Right here.
That just says to prove the time of the crime of attempt.
This is literally reading what you have here. I didn't change anything.
Right, but those are the elements of,
Attempted robbery is what he charged with.
So.
No change to what you have there. It's essentially put the attempted as it's charged first. And then define robbery with. No, no, no. Hang on.
So the way I'm understanding what you're wanting to do is to have the count 2 read attempted robbery, and then start with the instruction that's found on page 19, attempt to commit crime, where it says to prove Thomas Stein attempted to commit the crime of robbery, the state must prove the following 3 elements beyond a reasonable doubt. And then,
And it's stop before the define, on page 19.
hold on one second, let me just get my thoughts out first. And 3 elements. Okay. So you have the attempt, and then right in the middle of page 19, it says the crime of robbery is defined as. Instead of saying that, you could say, start with the top of the page 16, where it says to prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable
That's
doubt.
what we have, essentially.
And then
the
just
top
go
of-
through the end of the instruction on robbery.
Top of page 19 to be listed as attempted,
Right.
and then read as it follows, correct?
Okay,
Instead of having 2 definitions of robbery.
right.
That doesn't change the law, it's just gonna be something I wing if I could show my trial system.
Yeah.
I'm talking about. So it's the same. Yep. Well, it's there, but it's all, it's not that wrong.
Okay. So we have somewhat of an understanding of that?
I do.
Okay.
So put
So
in
we're-
how I understand it and we can revisit it.
All right. The next one is page 20, possession of a firearm. Any objection?
Just remove the principal instruction does not apply.
Okay. The next one, page 21, lesser included crimes.
We asked again, independent act to be included as to count 2. before we
Okay.
move on.
And then it said, and also the lesser included crime should be attempted robbery. Is that correct?
That's correct.
So make it attempted robbery, and then what was the other thing you said?
Independent act before we move on.
Before lesser included crimes?
Correct.
Okay. All right. Count 2, lesser included crime, theft.
No changes.
Okay. Lesser included crime, assault.
Again, independent act before we move on to assault.
So independent act after each lesser included.
That's correct, Your Honor.
Okay.
We'll create that, those instructions. That's independent, I think, every lesser.
But other than that, page 23, any objections?
No objections.
Okay. And then count 3, robbery, I assume it's going to be the same changes as to the count 2.
That's correct. They're attempted and defined attempted robbery, and then move on to robbery.
Right.
definition.
Okay. Let me go on to page 28, possession of a firearm, any objection?
Just the principal instructions are outlined, remove that.
Right. And then page 29, lesser included crimes. and change it to attempted robbery.
Correct.
And then before that, you want the independent act. Okay. And we'll go through all these again. Count 3, lesser included crime theft.
No changes.
Okay, then add in the independent act.
Correct.
And then count 3, lesser included crime assault.
No changes.
And then add in the independent act.
Correct.
And then count 4, again, the same changes that we did in counts 2 and 3 as far as attempted robbery and the attempted acts, or attempted independent act, I'm sorry. And then in page 34, I just noted, it does say to be found guilty of robbery or attempted robbery, but they're not, the defendant's not charged with robbery, it's just attempted robbery, correct?
That's correct, Your Honor, should be attempted robbery, and the same goes for the previous count.
Okay. Then page 36, possession of a firearm.
Just remove the principal theory, principal instruction.
Lesser included crimes, page 37. And same thing as far as lesser included crime should be attempted robbery.
Correct.
Okay. And then added the independent acts after each crime that's each charge. Okay. Count 4, lesser included crime theft.
No changes.
All right. Count 4, lesser included crime assault.
We're adding the independent acts, correct. No changes to assault.
Yeah, just adding in the independent acts. And then page 40, principles.
We request the language to include in the bottom.
That's
however-
right.
Yeah.
The state didn't
Might be in there
object.
already.
Okay. We'll add that in. Here's the independent act instruction, page, didn't have a page, but that's the one you wanted inserted behind each of the charges.
Correct.
Page 41, plea of not guilty, reasonable doubt, and burden of proof.
No changes.
Count 43, or no, count 40, page 43, weighing the evidence.
I think 9 and 10 should be removed from weighing the evidence.
Agreed, Your Honor.
Okay, we'll take 9 and 10 out. Leave the others in. In this page 44, we take out the accomplices and informants, or leave that in, I'm sorry, or take out the italicized portion of that.
Correct. We want to keep that in, just.
And just take out the parentheses or the brackets, I guess. This should be
So,
taken out.
Promised immunity from prosecution will come out.
I'm sorry?
Promised immunity from prosecution will be out,
Yeah.
because there was no.
Should be, for example, a witness who claims to have helped the defendant commit a crime, hopes to gain more favorable treatment in his own case, and may have a reason to make a false statement.
We agree we can remove the promised immunity.
I'm sorry?
We agree we can remove the language has promised immunity
Right.
in prosecution.
And then make it his and not her.
Incorrect.
Yeah. All right. And then take out the italics of give only if defendant testified.
Correct.
Defendant did testify, so we will keep that instruction part in. Page 46, defendant not testifying, we'll take that out because he did. Defendant statements.
We have to remove that. Want to keep that?
Was there a statement made?
No, he invoked.
Okay, so we'll take that out. Page 47. Rules for deliberation. Any objections?
No.
Cautionary instruction.
No, Your Honor, no objection.
Verdict.
No objection.
Should do first degree felony murder for count 1.
Wait. On page 50?
On page 2.
Are we looking?
Before the actual verdict.
Oh, you're talking about the, okay, sorry, I think you're the No objection.
to the verdict.
All right, then we get some verdict form.
So we should have count 1, first degree felony murder, and then A would be first degree felony murder.
Okay.
And I think attempted robbery looks correct now.
Correct.
Any other objections onto the verdict form?
No, those 2 pages, no, Your Honor.
So it's just
Felony murder.
first degree felony murder.
Correct.
And it was there another change?
No, just the first degree felony murder.
Okay.
Count 1, subsection A.
All right. Then special findings special finding as to first degree murder, we'll make that first degree felony murder.
Correct.
Also in the body of it.
And Judge, number 5 is added to the typical because that's encapsulated because he's a juvenile. So that's why 5 is added, which I think defense agrees to, but I just want to make that for the record.
Okay.
It feels a little redundant, but
I believe we can remove section 2 and just include section 3 as a new section 2.
I'm sorry, say that again?
We asked that we remove section 2.
Of the special finding as to first degree murder?
Correct, Your Honor, because 2 and 3 are very similar.
these are part of the firearms language that the questions that the jurors have.
For the enhancements?
Yes, 5 is the juvenile,
Right.
juvenile finding that has to be, so I don't think we should mess.
And you can explain that as you're going through in closings, what they mean. So,
And are we treating 2 and 3 as it is?
I think so. I mean, that's statutory findings for the enhancements that the jury were defined as. All right, and then special finding is a second degree murder. And these are the same findings that you did in the first special finding, it's the first degree felony murder. Okay. And then special finding as to manslaughter. Okay. Special finding as to count 2, attempted robbery.
No changes.
Special finding as to count 3, attempted robbery.
No changes.
And special finding as to count 4, attempted robbery.
No changes.
Single defendant, multiple counts.
No changes.
Submitting case to the jury.
You want to include the legally interlocking counts?
Yeah, that goes, but you have no objection to that?
Okay. No.
Okay, 2 things to address. If they're asking for the independent act for manslaughter, while I don't think it applies, we're willing to give it. So if they want that, we'll add that in after
Okay.
manslaughter.
Thank you. Yes.
Okay.
And then we discussed this morning, for the first degree felony murder, I believe that we should have, and I put that single instruction on your bench this morning, the legally interlocking counts as the first degree felony murder. I think that's required. I don't see that it's discretionary. So I gave a copy to the defense. I don't know if they're in agreement. I would assume they would be in agreement.
Okay.
So
So we'll include that.
Okay, so it would go after single defendant, multiple counts, the legally interlocking counts.
All right. All right, I am gonna let you all make those changes. I'm gonna temporarily get rid of this so I don't confuse it with any new packet. And
And no changes as to submitting, basically, the last page.
what's that?
No changes as to the last page.
Thank you. And so what we'll do is let you make those changes. The jury should be here. They're here ready to go. All right. Are you all ready to go then?
Once the jury instruction is ready, do you want,
Well, tell me what we're doing.
so she's gonna make the changes,
Mhm.
so I would assume, you want that done before we do closings?
Well, that's what I wanted. Are we doing closings or are you calling
Oh,
rebuttal
yes,
witness?
we are not calling any rebuttal.
Okay,
Sorry, I
that's
didn't
what I
know
wanted
you were
to know.
asking. Yes, we're ready
All
to
right,
go
so she
into
can go make
closings.
those changes
Yes.
and then we'll bring the jury in and do closing arguments.
Correct.
Okay, very well. All right.
Should we in recess until?
We'll be in recess then. And jury comes in at 9, and I'd like to start back up at 9 o'clock if we can, or as close there too.
10, it's 9:05.
10. Oh, they're coming. I'm sorry. Thank you. 10. Thank you.
I just need time to shove the replaced ones into.
I'll give you all
another
time. Just go ahead and
reference.
do what you need to do. Let me know.
Defense and state
That's
have
fine.
both looked at the changes and approved, and now they're just at the criminal.
Very well. All right.
Judge, we do have two issues we could address before going into closings.
All right.
The first is we had objected during the voir dire about talking about how the defendant sits here, he can get light, talking about his potential sentence. We would move in limine that not be discussed or argued to the jury, as it's improper for the jury to consider the sentence.
Okay.
He may not receive.
All right, Mr. Wheeler.
Judge, I think the defense is allowed to infer that Mr. Horn is a co-defendant of Mr. Stein, and his sentence would be approximately the same as Mr. Horn's. I am allowed to talk about his exposure, Judge, and certainly the deal he has with the state to...
Mr. Stein?
No, Judge, Mr. Horn.
You can talk about Mr. Horn. You can't talk about punishment for Mr. Stein. I don't think that's proper. Is there anything, is that, you agree with that?
I do.
Okay. But certainly they can talk about Mr. Horn.
Of course.
So,
Just as long as they don't relate it to Stein.
yeah, I think you were making the extra step to say, well, whatever Mr. Horn could get, Mr. Stein could get as well. You need to consider that. They can't consider potential punishment of the defendant.
Correct, Judge, that is correct. But I think that the jurors may take whatever inference they may from...
As long as you don't say it.
Yes, sir.
Okay.
That's the rule.
And then the only other thing is we would just ask that the court, there's a courtroom full of people, some here are new probably.
Okay.
That you just give your standard.
Sure.
instructions.
Obviously, this is a courtroom. There are rules of decorum established by an administrative order signed many years ago, still is in place. And so the courtroom is a solemn place where the jurors are expected to be able to do their work without any influence or intimidation or anything or cheering either way. So just understand you have to remain silent, no gesturing, rolling eyes, anything with, putting your hands up in the air or thumbs up, thumbs down, any kind of an indication to the jurors any kind of communication to them while they are considering the case, obviously. So just, and if you need to have a discussion or talk with anybody in the courtroom, I will tell you need to go outside in the hallway, have that discussion, and then come back in. Everybody's been very polite, and so I appreciate that. I just expect that to continue through the closing arguments, as well as if the jurors come back for a question, or if they end up having a verdict or something like that. The rules are the same throughout until the trial's over. Does everybody understand that? All right, thank you. How long do the state and defense expect their closing arguments to be?
Judge, for the state, for both of ours, between an hour, 15 minutes.
Oh, that's fine. Okay. Mr. Wheeler?
I'll take whatever they got, Judge.
Okay. All right. I'm not limiting you. I just want to know for scheduling purposes. It's, we're about 30 minutes later than when I planned on starting. Part of that's because of the jury instruction changes, I think, that were received early this morning. It takes us time to get those done. So I would prefer to have those done earlier over the weekend, but it is what it is. So probably end up doing closings and then maybe let them go to lunch and then come back after lunch, and I will read the jury instructions and let them begin deliberating. I think that's the way the timing will go then, based on what y'all are telling me. And again, just for members in the audience too, if you see any jurors at lunch anywhere out in downtown or anywhere else, please do not communicate with them to say anything about the case, discuss anything with anybody else in earshot of any of the jurors. You can do it there if you want. All right.
It's easier back in the office, Your Honor,
Okay.
because I have to reprint them anyway.
Okay. Any idea how many pages we're up to?
72.
Okay. It's all right.
We have in front of it, we found some more issues, so
Okay.
we have to reprint them.
And Mike, the jurors have coffee and snacks and everything back there. Thank you so much.
Snacks they didn't have because normally we do.
That's fine. That's fine. Thank you.
Did they anticipate that we only spent like 15 minutes for her after it was all done?
Okay. All right, then we'll be in recess for about 15 minutes. I'll come back in.
All rise. You see it.
know y'all are still trying to make changes, correct?
Yes, they were being printed again.
Uh,
Yes.
Other changes? New changes?
Yes. Not new that we talked, they wanted it, not new that we talked about. They looked them over, approved them, and then found some other things after they were printed.
Okay,
It's
so,
an independent act after every single charge.
right.
Right.
And I guess the only thing is, I feel like this is unfair to the jurors who are waiting back there unnecessarily. That's why I ordered you all to do this over the weekend. Monday morning is not the weekend. So is there any reason why this wasn't done Friday, Saturday, or Sunday? Mr. Montoya?
Judge, you should be looking at me. That was my responsibility.
So is there any reason why?
I had plans this weekend I couldn't get out of them, and I responded to Ms. Miller. I started last night, but this course was very limited.
Okay. Just understand the inconvenience, the unnecessary wait the jurors are having. So that's why I wanted y'all to do it over the weekend. When I ordered y'all to do that Friday, I wasn't informed that you had plans that would prevent you from doing that. So I relied upon our discussion Friday that these changes would all have been worked on over the weekend rather than this morning. But that being said, it looks like we've got a new packet.
I just have to shuffle in what I'm presenting during my closing. It's very short, but this is the first I've gotten, and I'm doing it very quickly here.
That's okay. I understand.
When I go through them while she does that, I've got a packet to make sure they approve them.
So as far as I understand, though, Ms. Wolf wants to insert the independent act instructions that we're going through. Is that what you're talking
Oh,
about?
no, just for her closing. She just is preparing her closing.
I just want to, I'm referencing certain pieces of the.
You're working on your closing.
Yeah, I just want to.
We can do the jury instructions.
Yes.
I'm sorry,
I thought
okay.
you were gonna close
I
out,
understand.
And I just needed a minute, sorry.
That's okay.
I've got
All right, so we'll go through them. You got your packet. All right. Introduction to final instructions.
No objection.
Statement of charge.
No objection.
Introduction to homicide.
No objection.
Count 1, first-degree felony murder.
No objection.
Independent act.
No objection.
Aggravation of first-degree felony murder by carrying, displaying, or using a firearm.
No objection.
Possession of firearm and discharge causing death.
No objection.
Lesser included crimes.
No objection.
Count 1, lesser included crimes, second-degree murder.
No objection.
Aggravation of second-degree murder by carrying, displaying, or using a firearm.
No objection.
Possession of a firearm and discharge causing death.
No objection.
Principles.
No objection.
Independent act.
No objection.
Count 1, lesser included crime, manslaughter.
No objection.
Principles.
No objection.
Independent act.
No objection.
Aggravation of manslaughter by carrying, displaying, or using a firearm.
No objection.
Count 2, attempted robbery.
No objection.
Possession of a firearm.
No objection.
Principles.
No objection.
Independent act.
No objection.
Lesser included crimes.
No objection.
Count 2, lesser included crime, theft.
No objection.
Principles.
No objection.
Independent act.
No objection.
Lesser included crime, assault.
No objection.
Count 2, lesser included crime, assault. Sorry. That's on page 31. Page 32 is principles.
No objection.
Independent act.
No objection.
Count 3, attempted robbery.
No objection.
Possession of a firearm.
No objection.
Principles.
No objection.
Independent act.
objection,
lesser included crimes,
no objection,
lesser included, count 3, lesser included crime, theft,
no objection,
principles,
no objection,
independent act,
no objection,
count 3, lesser included crime, assault,
no objection,
principles,
no objection,
independent act,
no objection,
count 4, attempted robbery,
no objection,
possession of a firearm,
no objection,
principles,
no objection,
independent act,
no objection,
lesser included crimes,
no objection,
count 4, lesser included crime, theft,
no objection,
principles,
no objection,
independent act,
no objection,
lesser, count 4, lesser included crime,
no objection,
principles,
no objection,
independent act,
no objection,
plea of not guilty, reasonable doubt, and burden of proof,
no objection,
weighing the evidence,
no objection,
um, I think in weighing the evidence on page 63, I'm looking for, where is the defendant in this case has become a witness?
the next page, Your Honor.
Oh, it is?
Before,
Oh, okay. All right, I see it. Never mind. Thank you. Okay. All right. Page 65, rules for deliberations.
no objection,
Cautionary instruction,
no objection,
verdict,
no objection,
verdict form.
no objection, no objection,
Okay. Okay, then we have special finding is the first degree felony murder.
no objection,
And special finding is the second degree murder.
no objection,
Special finding as to manslaughter.
no objection,
Special finding as to count 2 attempted robbery.
no objection,
Special finding as to count 3 attempted robbery.
no objection,
Special finding as to count 4 attempted robbery.
no objection,
And single defendant, multiple counts.
no objection,
Legally interlocking counts as to first degree felony murder.
no objection,
And submitting case to the jury.
no objection,
All right. And then I have our alternates as jurors 77 and 29, correct? So at the end of the instructions, I'll make sure they stay here. But those are the two that we want, that were selected as alternates, correct? From the state and defense. 77 and 29.
Give me 1 second, Judge.
That's okay.
That's correct, Your Honor.
Okay. All right. Are we ready to bring the jurors out for closing arguments? Defense ready. All right, so it's 11:15. The state's saying their arguments may take an hour, hour and 15 minutes or so. So we'll probably let you do your beginning closing argument. I'll let them go to lunch and come back and do yours. What?
Judge, they're going to be shorter than me because they're also going to have a rebuttal. So I would ask that we, the state's first opening closing argument, allow me to do my closing argument and come back to the rebuttal.
But then that means the jurors will not go to lunch until probably 1:15, 1:30?
No, because I won't, if I don't do mine, like the total, we're an hour and 15 minutes for both of ours.
Oh.
If we just do hers and his.
Then we can let them go to lunch.
Correct.
Okay, that's fine. I'm sorry. Okay. All right.
Uh,
Is that, everybody agreed on that scheduling wise? Okay.
I would ask though, if the closings aren't as long when they need to go to lunch, that I could just do my rebuttal. But I'll let you decide
That's fine too.
time-wise.
Yeah, that's fine
I
too.
would prefer to do it, but if
if
they need to eat.
Yeah, we pushed up against the lunch hour for them now, so I want to make sure at least they haven't had anything to eat yet, so.
Unless they bring any snacks.
I don't think they have snacks right now.
I didn't put them
Yeah.
after we did deliberation.
So, anyway,
All right.
all right. Are we ready to bring the jury in?
Yes.
Defense ready? All right. Let's bring them in.
Yours entering.
All right. Please be seated. Welcome back, ladies and gentlemen of the jury. By a show of hands, was anyone not able to follow the court's previous instructions about doing any research, looking up anything, or discussing anything about their service as a juror on the case? Seeing no hands, we're ready to proceed. So, ladies and gentlemen, both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. You may proceed.
May it please the court, counsel, Mr. Stein, ladies and gentlemen. On March 17th of 2024, Kayla Rincon-Miller was shot and killed during an attempted robbery that targeted both all herself, Luann DeJet, and Emma Wright. That's what this case is about here today. The perpetrators of that robbery arrived in a gray Nissan Pathfinder that was driven by the defendant, Thomas Stein. That vehicle stalked those three girls back and forth on a dark road where those three young women were all alone. Ultimately, that car made a U-turn, back, flashing the high beams at the three girls, and immediately the occupants of that vehicle jumped out saying, "Give me your shit." This was a robbery from the moment that happened. Each of those three girls had guns in their faces by their attackers. In moments from those car doors opening, shots rang out and Kayla Rincon-Miller dropped to the ground. The car, filled with all those occupants again, raced away directly back to the home of Thomas Stein. Over the course of the trial, you received as jurors a whole host of evidence. And quite honestly, in this case, it ran the gamut of the type of evidence that jurors can receive in a case. You heard testimony from eyewitnesses, testimony from investigating officers. You saw video evidence, that PowerPoint that put together all of those points of travel, the hertz tracking, the tower data from cell phones, the license plate readers, the traffic cameras. You heard forensic evidence from the crime scene technician who went to the scene of the crime and collected the evidence. You heard some forensics from Amy Schober, who put together some information from you based on the details of the investigation related to the firearm and the injury to Kayla Rincon-Miller's chest. You also heard from a medical examiner about her expertise and examination of the autopsy that was conducted on Kayla Rincon-Miller. And you also had the benefit of hearing from both of the two charged co-defendants in this case. The court will be giving you a whole series of instructions, and we often refer to it as a packet. But honestly, in this case, it's essentially a book. It's large, it's voluminous, it's going to take a little while to get through them, but as jurors, you will get a copy of that to take back with you. So you don't have to be concerned about taking notes and trying to remember what the law is and the other information provided in those instructions, because not only will the court read it out loud on the record, but you will get a copy of that to bring back into the jury room with you. And as Judge Thompson indicated, the structure of these closing arguments is that the state gets the opportunity to address you first, the defense gets the opportunity to put on a closing argument, and then because the state bears the burden of proof in a criminal case, we get the opportunity to address you again through rebuttal. And so I want to take my time during this closing argument to talk to you about some of these instructions that you're going to receive from Judge Thompson. A lot of them are somewhat common sense, things like weighing the evidence, about discerning whether someone's telling the truth or whether you find something to be reliable or credible. And then the other instructions that you get relate directly to the laws and only the laws that apply to this case. So I want to go through that briefly here with you. I'm going to put the first one up here on the screen, and one of these instructions is called weighing the evidence. And the point of this instruction is that you can believe all, some, or none of everything you heard here during the course of the trial. It's up to you as jurors to determine what you believe, what you think fits with the other evidence in the case, and simply what makes sense to you based on your assessment of that testimony and evidence. You determine what's credible and what's reliable, and this is that everyday concept of trying to decide what is being told to me and whether that's true. Things like, did the witness seem to have an opportunity to see and know the things about which they testified? Really basic example, did the arriving officer, Officer Vega, who arrived on scene, try to talk to you about the autopsy? No, that's an exaggerated version of that. But at the same time, did the girls who were the eyewitnesses to the event that survived, did they try to talk to you about what their perceptions were based on the very extenuating circumstances of the trauma they experienced? We can't forget that Luann Dejet and Emma Wright were not just witnesses to their friend being shot and murdered in front of them. They were victims of an armed robbery themselves on a dark road in an unexpected event. So you have to consider what they heard, what they saw in that context. Additionally, you have to consider whether the witness had an accurate memory. Were they honest and straightforward in answering the attorney's questions? And that goes for both sides. Some of the questioning got a little bit contentious, and you can consider how those questions were asked, how they were responded to, and also the nature of the questions. Were they confusing? Do you believe the witness understood the questions being asked of them, and was the response responsive to that? Were they evasive in trying to answer those questions? I'm going to skip down here. Does the witness's testimony agree with the other testimony and other evidence in the case? We had the benefit of having this whole stream of data that includes that track with the GPS on the Hertz car, the cell phone tower data that tracks right along, and those license plate readers. That's the kind of thing that is consistent with the testimony that you heard from the witnesses in the car, Thomas Stein and Christopher Horn, about the path they took and what they did. I'm going to bring this up here. Has the witness been threatened or pressured to give testimony? Have they been offered a benefit? You can consider that. It's important that you can consider that and whether that person provided testimony willingly. Does the witness have an interest in the outcome of the proceedings? That's important as well, because the defendant made himself a witness in this case when he elected to testify. It's on the last page of this instruction. You can consider all of the things that you would consider about any other witness and their testimony and reliability and credibility the same way that you consider the defendant's testimony. One of the other things that is important we discussed during voir dire has to do with reasonable doubt. And in this whole book of instructions you're going to get, it's loaded with definitions. This means that, this is defined as something else. You're going to receive all of that. But what's really interesting is that the definition of reasonable doubt is actually a non-definition. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. What you're going to learn from these instructions and how you are to consider the evidence is that we can tell you what a reasonable doubt is not. If you're having to force yourself to imagine that this was not a robbery, you have to force yourself to believe this was just a couple of kids, they didn't know what they were out doing, that is not a reasonable doubt if you're having to force yourself to do that. If you believe Thomas Stein was trying to be a hero that night, but you're having to force yourself to come to that conclusion because just because he said it on the stand and you're having to say to yourself, well, he said it, but it doesn't really make sense or jibe with the rest of the evidence I heard, that doesn't form a basis for reasonable doubt. Because the concern is whether there's an abiding conviction of guilt. If you as jurors believe that this was a robbery from the start, you don't have to force yourself to imagine that it was something other than a robbery from the start. And you shouldn't be influenced by forcing yourself or imagining or speculating about what could have been or maybe it was this way. If you believe this was a robbery from the start, it was a robbery from the start, and you don't have to force yourself to imagine alternate outcomes or scenarios. All of the instructions you're going to hear are going to include a reference to what's called principles, and this was discussed again in voir dire. This is that idea of in for a penny and in for a pound. We talked about this in voir dire under the concept of the house party. There's not a criminal activity going on, but these two individuals threw a house party, the person who holds the door and the person who invites everyone over and gets the beer, those people are equally involved in that because they both participated. And the actual instruction reads that if the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did. In for a penny, in for a pound. In Florida, we do not let defendants hide behind the actions of other co-defendants. If this individual was involved in a robbery, everyone involved in that robbery is equally responsible for that crime. Say it again, in for a penny and in for a pound. This is important in this case because what we know is that Thomas Stein was the driver the entire night. Thomas Stein armed himself and he armed Christopher Horn. The two guns they carried that night came from Thomas Stein himself. And by that was by Thomas Stein's own admission that he had given that gun that had been Darrell Ford's gun to Christopher Horn. That 1911 we see flashing around in that rap video just not even an hour before the robbery with the red laser light, that's that 1911 that Christopher Horn was handling. But Thomas Stein provided that. That wasn't brought to the event by Christopher Horn. Thomas Stein armed Christopher Horn. And he didn't arm him in anticipation of going car hopping. You heard what car hopping was, jiggling door handles to see what we can find inside. There's something missing from that concept, and it's the need to use force with a firearm. You can use your common sense about why a firearm was needed that night. Gun was needed that night because the plan from the jump was that this was a night of robbery. The plan was never just to stick to car hopping. You can consider the testimony that you heard from Thomas Stein. He was okay with car hopping. And then the plan backed down because he just didn't know what was going to go on. These other individuals got in the car. I don't know what we were doing. I just was driving. Interestingly, he drove directly to a second movie theater. Keep that in mind. They'd been at a movie theater and driven through the parking lot at Merchants Crossing Theater, the AMC in North Fort Myers, himself and Christopher Horn earlier that night. They wrangle, they decide what they're going to do, and where do they go? Directly to Cape Coral, directly to the Marquee Cinemas, and drove through that parking lot. You can review that GPS data, but you heard Destiny Robidoux talk about the timing of that. The vehicle didn't stop in the parking lot. There was no one jumping out and jiggling door handles to see if they could find someone left their car open and left some weed or some money in the car. They were stalking a target for their robbery. When Thomas Stein was asked on the stand, once you picked up the other people that you're saying you picked up in the church parking lot, what was the plan? Speechless. He had no answer because the answer is they were going to rob someone. He couldn't come up with something from the stand to tell you about what the plan was that night that wasn't incriminating as it relates to this felony murder charge. This principal instruction is going to come up over and over and over again during the instructions because this concept of in for a penny, in for a pound applies to all of the criminal behavior. I'm focusing on this robbery because that's the main charge that we're here for, but you are going to hear it on every single charge that you're going to be instructed on. And you can consider that in your deliberations. Count 1 of our indictment charges first-degree felony murder. To convict the defendant for first-degree murder, and I'm going to emphasize this, I've highlighted it here, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. They didn't have to go out that night and plan they were going to kill someone to take their property. The point of felony murder is that they planned to do a crime that is so inherently dangerous that any death that results from that crime is first-degree felony murder. That's the point of this law, and you went through that during jury selection. This is that arson example. Some crimes are so inherently dangerous that it's reasonable to expect that your actions will result in a death. Arming your friend to go out to commit a robbery is what the defendant did. That action is inherently dangerous. And that's why he's guilty of this felony murder at a minimum. That's the very least of the evidence that implies that the defendant is guilty. The elements that you see here are the elements that the state is required to prove. First, Kayla Rincon-Miller is dead. It's not at issue. That young woman was a 15-year-old girl. You saw the autopsy photos of her laying out after being deceased. You heard from the medical examiner an autopsy was conducted. You saw a copy of the death certificate. That's in evidence if you'd like to look at that. She died due to a gunshot wound. She is deceased. Element number 1 is not at issue here. Element number 2 calls that while engaged in the attempt to commit a robbery, Thomas Stein, and I've circled it here, or Thomas Stein's accomplice caused the death of Kayla Christine Rincon-Miller. What that means, you can lift some of the burden of this case off of your shoulders, because for this charge, you are not required to know or decide or determine who pulled the trigger. The only question, which is very, very, very narrow, is whether these individuals were engaged in a robbery at the time Kayla died. A lot of this case could get blown up as being a much bigger, grander issue. But element number 2 makes clear that this is a very, very narrow issue. Were these individuals engaged in a robbery or an attempt to commit a robbery at the time Kayla Rincon-Miller was killed? It doesn't have to be Thomas who shot her. It doesn't matter. The question is, as a group, were they participating in an inherently dangerous criminal act, and as a result, Kayla Rincon-Miller was killed? The answer is definitively yes. But let's talk about what that robbery means. You get a whole instruction about what robbery is and what attempted robbery is. I want to talk about that, and I think it's easiest to work backwards. So at the end of the instruction, you get this principles again that I told you you would see pretty much on repeat, okay? The principle theory applies to the robbery that we're talking about. If Thomas Stein did anything to incite, cause, encourage, assist, or advise, then he is a principal. And if he's a principal, again, then he is treated as if he had done all the things the other person or persons did. The attempt simply means they tried to do a robbery, but they failed. You heard there was a scuffle, a struggle. Kayla fought back against the person trying to rob her. Emma had a bag across her body. She was not giving that bag up. Luann DeJet had a bag under her arm. She didn't give that up. Just because they weren't successful at committing this horrific attempted crime, it doesn't mean that they get away with it. If they attempted to do it but failed, it's still an attempt to commit that robbery. And then the elements about the robbery itself. And here, it's important to remember that principle, because where you're seeing Thomas Stein, it's Thomas Stein or one of the perpetrators together, if they're acting in concert with one another to effect this robbery, did take or try to take the purse from Kayla Rincon-Miller. That force, violence, assault, or putting in fear was used in the course of the taking. You can think about the rapid nature of how this happened. Once that car turned around, the lights flashed, the doors open, and in an instant, give us your shit, give me your shit. It was a robbery. Those girls, despite thinking at the moment this might be a prank, it's because it was terrifying. They were armed individuals with these girls on a dark street where there was no one else around. The fear that was used, that's the point of bringing a gun to a robbery. You want to scare the victims into giving the property that they're trying to take. And the point is that the girls did have items of value. They may not have had a ton of money with them. Their purses had value. They had items in their purses that had value. And the point is that they were trying to take something that didn't belong to them, and it wasn't just a joke. They weren't taking it temporarily to give it back. You can infer that from the testimony that you heard. And again, that rapid nature of how this took place. This robbery was the plan from the beginning. Thomas and Christopher Horn's plan, and also if you believe the testimony from Thomas Stein about picking up those other two individuals in the church parking lot, it was their plan as well. And we know that both because of how Thomas behaved in operating that vehicle. Think about what I talked to you about in opening statements. They're driving through that movie theater parking lot. It's a well-lit area. The bank, vehicles there at the ATM, well-lit area with cameras. What did they do? They identified what they thought was a soft target. 3 girls walking down the road alone. stalked behind them to check it out, turned around and came back to get a better view, committed to the plan by making that U-turn and passing them again before turning around to blind them with their lights. That's not a couple of boys out trying to holler at some girls. Those are criminals looking to rob an easy target and scoping out the best way to do it. We also know this was the plan from the beginning because, again, they went armed. I'm not going to keep harping on that. It's like you don't bring a gun to a fist fight. You don't bring a gun to jiggle door handles to try and find small amounts of weed and pocket change in a center console of a vehicle. And again, what you heard from Emma Wright and Luann DeJay about what happened when those doors opened, it was immediate. Everyone was out. The boys were at them in moments demanding their belongings. This idea and this charge of felony murder means that you do not have to decide who pulled the trigger. But if it was one of the people who's working in concert with Thomas Stein, then he's guilty of felony murder. They don't have to have known each other before they did this. If the plan was to do a robbery together, they're each responsible for the action that resulted, which was Kayla Rincon-Miller's death. This is only the case of State versus Thomas Stein. We're not here in case the State versus Christopher Horn or the State versus any of the other perpetrators. Your job here is only in regard to Thomas Stein. Again, Thomas Stein supplied the car, he supplied the weapons, he has supplied the escape. And what did he do after the murder? He burned his clothes, he got rid of the gun. That's not the activity of someone who merely wanted to intervene to help a girl who was being robbed. That's what he asked you to believe when he testified on Friday. He got out of the car bewildered. What's going on? The shooting happened, and then he said, oh no, that's too much for me. Let's get back in the car and go home. Those two stories don't line up. He wants you to believe he was going to be the hero that night and rescue Kayla from JD, who was going to jump out and was struggling with her, and they were fighting. Because I'm just going to get between them. Just going to get between them. Weigh that evidence to decide whether you think that's credible based on the circumstances, based on him driving the car that stalked those girls in order to do that robbery. It's easy, again, to get distracted because this is a highly emotional case. There's a lot of moving parts, there's a lot of pieces, but it's that very limited issue. This was a robbery, and Kayla Rincon-Miller died as a result. And then here in element number 3, in first-degree felony murder, Thomas Stein was the person who actually killed Kayla Rincon-Miller, or she was killed by a person other than Thomas Stein, but both the person who killed her and Thomas Stein were principals in the commission of the attempted robbery. That's that element 3. The instructions about murder can be confusing and they can be overwhelming. You're going to receive other ones that are also very verbose about excusable homicide, inexcusable homicide. What this boils down to is what's contained in the first part of this felony murder instruction. You don't have to be distracted by those. You have to listen because it's important. The Florida law requires that you listen to those instructions and consider them. But when you try and process what you've heard, it boils down to this. That's why we're here today. The primary question is, was Thomas Stein involved in the robbery? When the answer is yes, the verdict is guilty as charged on count 1. The verdict form, there's an instruction before you get the verdict form, and it talks about if you return a verdict of guilty, it should be for the highest offense on the verdict form that's been proven beyond a reasonable doubt. You're going to receive information on some lesser included offenses. I'm going to talk about this briefly in a moment. But I bring this up because first degree felony murder, letter A on the verdict form that I'm going to show you, is the highest offense charged for count 1. It's just in case it would be confusing. This is a copy of the verdict form. I placed it on the viewer. The special additional instructions that you're going to get are related to count 1. Those involve whether Thomas Stein actually possessed the firearm. Did he have a gun in his hand? Was he armed at the time? Those are all special instructions that the judge has to give you. Those questions are answered on special findings forms after the verdict form. And it can be kind of confusing, but the judge is going to give you the full instructions. So if you find the defendant guilty of first-degree felony murder, you have to answer each of these questions. I want to point this out because what you answer on this special findings form has no impact on whether this is felony murder. The robbery gone wrong relating in the death is one inquiry itself, and if you find guilty of that, then you have to answer these questions. But if you find that the defendant didn't have a gun at the time, it doesn't mean he's not guilty of the felony murder. And I just want to make sure that everyone's clear on that because these are voluminous and somewhat confusing instructions. In addition to this main charge in count 1, you will receive instruction on lesser included offenses. And when you hear those instructions, you might think to yourself, oh, that kind of sounds like this, or maybe it's this instead. And I want to point out that second-degree murder, it's a killing. Someone's dead, in this case, Kayla Rincon-Miller. But what's missing from the second-degree murder instruction is that it was committed in the course of this inherently dangerous crime. The court is going to instruct you on this, but I think it doesn't apply here because where we're at for the highest offense charged is that this was a robbery, and in the course of the robbery, Thomas Stein, or one of the co-actors, also committed the murder. That's what makes it felony murder. And so second-degree murder is something you're going to receive an instruction on, but we're missing that component of it being committed in the course of this dangerous crime. Same thing goes for manslaughter. You'll receive an instruction on this. And again, there's someone who's been killed, but again, it's missing that component of it being in the course of this very dangerous crime. We have just a moment. I want to emphasize when you're thinking about second-degree murder and manslaughter that this was a robbery from the start. Thomas had secured the vehicle to drive, which, mind you, was his mom's rental vehicle as a 16-year-old. He obtained the guns, which he says are normally stored in his mom's gun safe, but he had to get those out, have access to them. He didn't just keep it at home like the marijuana he says he's allowed to smoke in his yard in a controlled environment. He took that rental car, he put armed people inside with his guns, and he went to the scene. Under no circumstance is it believable that Thomas Stein is the only one in that vehicle that didn't know this was going to be a robbery. And that's what you'd have to believe to think that this event happened the way that Thomas Stein told you that it happened. He asked you to believe that these people got in the car. They're a lot more thug than him. He really didn't know what to do. They were Christopher Horn's friends. Is that plausible? Does that make sense? You watch the video that they made 45 minutes before Kayla's murder, what they were going to get up to. Is it plausible that Thomas Stein is the only one? He's the innocent party here. He didn't know what was going to happen. Going back to those considerations about those special findings forms, I want to talk to you about how the principal theory that we've gone over and over doesn't apply to those. The special findings about whether Thomas Stein possessed a firearm, whether he discharged a firearm, those are specific to Thomas Stein, so I don't want you to be confused. And again, your determination of that doesn't have any impact on the finding of felony murder. But it's important because you heard some evidence that you can consider about whether it was Thomas Stein who fired that shot. You heard from the medical examiner, and I'm placing Exhibit 7D up on the screen. You heard from the medical examiner that this image was taken of the gunshot wound to Kayla Rincon-Miller's chest. She pointed out to you this area of abrasion here in the photograph. And she told you that as far as her experience in doing hundreds of autopsies, that that's not from a medical intervention that she's familiar with. How did that get there? And that question was set out to be answered by the investigators in this case. And they did a lot of legwork to try and figure that out. There was a video that you saw of Thomas Stein holding a Glock 27 weapon. That's exhibit 23. Should I give you the right number? Exhibit 23. A screenshot from that was taken of Thomas Stein holding that Glock 27. And you heard from the detectives that they were able to slow that video down and identify a serial number on the gun. And they worked to identify that serial number and learned that Thomas Stein's mother had purchased a Glock 27. You also heard that during the execution of the search warrant, that Glock 27 was not at his house. The detectives asked Amy Schober to try and run with this to try and figure out if that Glock 27 could potentially be involved. She didn't offer you an opinion. This is up for you to determine how this evidence fits within the case. But she told you that she checked out or viewed a gun at a local gun dealer. This is State's Exhibit 26. It's really hard to see a little bit there, but these images can go back with you into the jury room. And she noted something about that firearm. And it was these unique markings, at least in this gun, this Glock 27, at both the back of the gun as well as where the muzzle is. So that's used to help when they're going to rack the slide of the gun. And she set out to at least present this evidence so that the jurors could see it here today. And she made this overlay that showed the front portion of that muzzle with those markings and whether they coincided with those marks on Kayla Rincon-Miller's chest. When you consider this evidence, along with the testimony of Dr. Noelia Hernandez, that this weapon was fired so close to Kayla Rincon-Miller, she said 2 to 3 centimeters. These markings are something for you to consider about where they came from. This case involves a tremendous amount of circumstantial evidence. It doesn't mean that it's not good evidence, because these pieces line up together for you all to make your decision. The remaining 3 counts in the instructions that you're going to get all are the same. It's just one separate for each of the victims, and that's the robbery. Excuse me, I misspoke. This is the attempted robbery. I have included count 2, but count 3, 4, and 5 are all the same. It's just that the victim is different. One for Kayla Rincon-Miller, one for Emma Wright, and one for Luann Dejet. And we've gone through what a robbery is when we're talking about felony murder, because that's the underlying offense that brought us here today on the felony murder charge. The principal instruction applies to all of these the same way it applies as we've already discussed. All of the evidence you've heard has to be considered by you in determining what occurred on that day. But you don't have to determine everything that occurred on that day. You have to determine whether Thomas Stein was a participant in the robbery, an attempted robbery, on March 17th of 2024. It's a very narrow question when you boil down all the evidence and what the law is that applies. The defendant's actions after the murder are really pertinent to your understanding of what his role was. I want to talk about that because both he and Christopher Horn burned their clothes. Both he and Christopher Horn got rid of their guns. Thomas Stein asked you to believe that he merely wanted to intervene between Kayla and the shooter. Why would he feel the need to burn his clothes? Does that make sense to you? Or does it tell you something else about what his role was that night? Thomas Stein told you a lot about that night. On Friday, he told all of us he knew who the shooter was. JD, some other guy, Trey, also got in the car. You can consider how his testimony carefully zigged and zagged within the testimony of the girls that you heard from at the beginning of the trial, as well as all the other evidence that had already been admitted by the time he testified. You can consider that. He sat before you and tried to paint himself as an attempted hero that night. He tried to paint himself as the victim, as the patsy for this entire event. He told you he was willing to stop a fight, but once that shot was fired, that was it, and he took off running. This would-be hero burned clothes. His mom exchanged the rental car. Exchanged, not turned in. She turned in that car and got in a different one the same day, the day after the murder, the morning after the murder. And then he sat here on Friday and told us all the name of the shooter, or at least the initials. He didn't help Kayla that night. He didn't try. He was not on the heroes team that night. He is not the victim here today. There are 3 victims in this case: Luann DeJet, Emma Wright, and Kayla Rincon-Miller. The state asks that you find the defendant guilty as charged of felony murder, of attempted robbery of Kayla Rincon-Miller, of attempted robbery of Emma Wright, and of attempted robbery of Luann DeJet.
Sweet.
Good morning, everyone. There was a robbery, right? Kayla was shot. And in the state's theory of the case, that equals felony murder. But there's a problem with that. So if there wasn't, why would I be here? Why would I be standing before you right now? The problem is that the law says the state must prove that Thomas Stein intended for this to occur.
Objection, the statement of the law.
Overruled.
There are 4 main lies told by Christopher Horn. 1, who the shooter was. The shooter was this guy, Jaden. This is just a made-up name I picked out of a hat. The shooter is Thomas Stein, right? In order to save his bacon, that's what he's saying. Another lie. What'd I do with a gun? I emptied it over here. No, I put it in the canal. Even in jail, he's telling everyone, no, I got rid of it in the canal. The police searched that canal. There's nothing there. What'd I do with my phone? Oh, I chucked it over the side railing of the bridge. It's sitting in the Caloosahatchee River. Well, guess what? The police looked for that gun, for that phone, and it's not there. And the biggest lie he's told is that there's only 2 people involved that night, right? You know, and the state keeps making the situation even weirder. It's just a couple of kids out, committing robberies. Or on the other hand, there might have been 2 other people involved, if you look at the evidence. Of the 4 people that got out of the car that night, only 3 had the intent to commit a robbery. Two people were arrested for that crime, but there's still 2 more people out there. And I'm guessing Ms. Miller at the end of this, right, she gets to give a rebuttal, is going to say something along the lines of, it doesn't matter if you believe there's 2 or 4, as long as Thomas Stein and Christopher Warner are involved. It's felony murder. And we're going to talk about why that matters. Because at the end of the day, there's only one person on trial today. That's Thomas Stein. You know, at the start of this case, the state makes all these promises to you in their opening statement, right? Do you remember? I asked you to write them down if you could. Because they had to keep those promises to you. And they said...
Objection. The statement of the law.
Overruled.
They said that they knew exactly who the shooter was and they could be identified. The state has served you 13 different witnesses. 13. Right? Let's pretend it's like we're sitting down for this fancy dinner. 13 different witnesses. 13-dish main course. Some, like Luann Desjai, very straightforward, right? Her testimony has been unchanging. She is a victim in this case. Absolutely, 100% agree with you. It's important to remember that sympathy is human, right? To have sympathy for someone, it's human. The empathy that we feel is normal, but we can't let it dictate what the verdict in this case is going to be. You guys in particular were selected, right, during that jury selection process for a very particular reason. Common sense. We thought you had the best common sense. We thought you could read people the best, right? Because we've established this is not a truth-telling box. You're only going to have, from the time it takes to walk from those doors to this stand, to size them up. That's all you got. Lastly, you were chosen because you have the intestinal fortitude, right? To stick to your guns, to deliberate this out. That if there's something wrong with this dish the state is serving you, you're going to send it back to the kitchen. The verdict in this case must be unanimous. That means you all must agree. Everyone here. Did the state prove the burden beyond and to the exclusion of all reasonable doubt, right? And here's the question. That Thomas Stein knew about the plan to rob Kayla, to rob Luann, to rob Emma, that he intended for it to take place and took part in the robbery. It's quite the opposite. And again, reasonable doubt, right? We talked about reasonable doubt during the voir dire. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. But on the other hand, if, after carefully considering, comparing and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates. The charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. You know, the state's talked about this principles theory, and I'd like to go over that jury instruction also. There's 2 things the state has to prove to you. Right? If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt. Here we go. 1, the defendant intended the crime to occur. You stop. Did the state prove beyond a reasonable doubt, right? Did they give you any evidence that he intended for this to occur? Testimony of one man, Christopher Horn. And the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. But there's a bottom portion of that instruction, and it reads like this. Mere knowledge that the underlying attempted robberies are being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to felony murder. We talked about this a bit in voir dire. When Mr. O'Brien, who's sitting over here, he's from, I think it was Boston. He's talking about the star athlete that had his whole life in front of him. And he was with those kids that went in and held up the store clerk. And now he's serving life. In Florida, it's a bit different. The state must show that there was intent for that crime to have occurred, right? You can't just sit there. It's got to be more than that. There's going to be a whole litany of charges that are read because the state says, well, if we can't get them on the felony murder count, maybe they'll come to an agreement as to second-degree murder. No, not going to agree to that. We'll go with manslaughter.
It's a misdemeanor law. It's mandatory.
Oh.
They can ask for lessers in this case, and they have. But after each lesser, you're going to have the same instruction on principles, right? And you're going to have the same instruction as to independent act. If you find the crime of attempted robbery was committed, an issue in this case is whether the crime of attempted robbery was an independent act of a person other than Thomas Stein. An independent act occurs when a person other than Thomas Stein commits or attempts to commit a crime which Thomas Stein did not intend to occur, in which Thomas Stein did not participate, and which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act as contemplated by Thomas Stein. If you find the underlying crime of attempted robbery was an independent act of another person, then you should find Thomas Stein not guilty of the crime of attempted robbery. And here's the thing, if you find him not guilty of the crime of attempted robbery, you must find him not guilty of felony murder. That's what we call an interlocking charge. Okay. So let's talk about the testimony that we received. And I'm gonna break them down in chunks with the exception of one. Detective Lassalander, I'm going to kind of save for the last because he was the lead detective kind of putting everything together. So in terms of law enforcement, our investigation witnesses, we have Officer Vega. He's first on scene, and he did his best to render aid to Kayla. But what do we know from his testimony? There are 4 or 5 subjects. He's fresh on the scene. We know there's 4 or 5 subjects. Gray SUV, going that way. One was a white male, 3 black males. Sergeant, gun. He failed to collect DNA from the hospital when he was on scene. And it's okay. We're doing okay. But why else call him? But for the simple fact to recount the very emotional moment Kayla's parents found out that she had passed. As heartbreaking as this account was, once again, we can't let sympathy guide us on our verdict. Next, we heard from Lansky, who is a retired CSI specialist. Of all the things that was found on the scene, of all the things that she didn't swap, thank God there was one thing she did, and that was the purse strap that was being held by Kayla Rincon-Miller. The purse strap that was being struggled over by her and her assailant. We know that Christopher Horn was excluded as a contributor. We know that there was a partial DNA profile developed, male contributor. But we also know that that male contributor is not Thomas Stein. So we know that there's at least 3 people, right? And if you believe the witness accounts, there's definitely 4. We heard from Officer Alan Precy. He got the license plate reader, kind of gave it the big break on the case, tracking the SUV. We heard from Destiny Robidoux, which is so close to Robidoux. Destiny Robidoux says that she was able to plot the map points, right, of the GPS from Hertz. We were able to plot the cell phone tower records from both Thomas Stein and Christopher Horn and his mom and Jaden Fernandez. We heard from Amy Schober, who is an employee at the Cape Coral Police Department. She's the CSI specialist, right? And I kind of fit this into the category of junk science. Am I crazy, or did she really say she photoshopped some evidence to see if it matched? It was made to fit. And that's the overarching theme of this case. Did she test any other weapon, including the 1911 that we know was on scene, right? Well, no. I just tested what Detective Lasalandra told me to test. She considers herself a forensic scientist. That's not how scientists behave. We heard from Detective Scarlato. He introduces this video with Christopher Horn, right? He's waving around this 1911 with the laser and the pistol grip. Terrible music, right? And the state is trying to make this connection. Oh, but listen to the lyrics. The lyrics themselves give you the plot. It doesn't. I heard this phrase, demon seed? What does that even mean? Detective Scarlato, he corrects Emma Wright's testimony, who said, I know that the shooter was not the driver. And we know the driver was this guy. We know that there's more than 2 people, according to his testimony. And that the shooter, in fact, was in all black and a red hoodie. We heard from Detective Noelle Hernandez that we don't know what the caliber of the murder weapon was. Glock 27 is a .40 caliber weapon. 1911 is a .45. But we don't know what it is. It was a through and through, right? So that means at least the majority of the bullet, we would think, passed through her remains. But we don't know if there were fragments that were still there. She didn't know if fragments were still there. She couldn't tell us. She wasn't the ME who did the original examination. In terms of non-law enforcement witnesses, we have Jessica Stein. She's a single mom of 8. She has 4 kids living with her at home. We put this picture of her home before you to consider. She tells us how she was threatened by the Horn family. Listen, it's very clear Thomas is going to be arrested, but I need you to keep my son's name out of his mouth. They even offered to pay for his lawyer. Not me. We heard that Christopher Horn Sr., Chris's dad, who's got some knowledge of criminality, says this is how you dispose of evidence. We heard from Jaden Fernandez, and now we're getting closer to the event. He's known Thomas for 2 years. They met at school. Just some neighborhood kids doing neighborhood things. And I don't know if you saw Thomas watch his friend testify against him, but he couldn't help but feel sad that but for this event, I could be going off to college. I could be playing ball.
Objection, improper argument.
Sustained.
You know, but he's got this strange category of friends, all right? We have Jaden Fernandez, who just spent the day with him and his family going to the beach. Very wholesome. You know, very teenage boy. Going up to girls, chatting them up. We asked Jaden, did Thomas have any ops? And for us older folks, ops means opponents or people that you have beef with. His face kind of screwed up. Thomas didn't have beef with anyone. And Thomas definitely never said, I want to rob a Chico. Or I want to catch a body. And these are two statements that Christopher Horn said. You know, Detective Salandra, he told us how the car stopped. And we know from the GPS records from Ms. Rabadou that it was for 7 minutes. The car stopped in a church parking lot, like they were meeting someone that's in there. The car parks next to him. We know this because the pastor was kind of seeing what was going on over there, right? We didn't hear from the pastor, though.
Objection, overt violation.
Sustained.
I'd ask to strike the comment by counsel.
I'm sorry?
I'd ask that the jurors disregard the remark by counsel.
I sustain the objection. Move on.
Detective Salandra confirms there were more than 2 people, right, that he's investigating. He confirms that the DNA found in the purse strap excludes Thomas Stein. He confirms that the investigation is still open. He says that based upon his investigation, there were 4 people, 2 guns. Not even the state's main investigator believes Christopher Horn Jr. Let's talk about the victims in this case. The victims are consistent with one thing. They said that there's 4 shooters. One, the most obvious, was a white male, right? We know this because he slowed down to 5 miles an hour as he passed him, and he's checking him out, his arms in the window. They could see that he has blonde hair, and he's looking at them so hard, and they're looking at him so good, they can tell he's got blue eyes. Another male that they saw was a black male in a red shirt, with loud writing across the front. He's in shorts, and he's got a mask on. A third male, heavy-set, black male, red hoodie, blue pants, who we can only assume is Christopher Horn Jr., wearing a mask. Finally, we have a black male with short twists, the t-shirt covering his face, and all black. We can only assume that this person is JD. But when I asked her about the 4 people at the scene, she makes this comment to us. She thought, I was talking to Emma, and we thought to ourselves, am I crazy? Am I crazy? Luann, what do you mean by questioning your own sanity? Why would you do that? Maybe we didn't see the things we thought we saw. We're talking about perception. Who told you there's only 2 people? The state did. Because that fits that square peg into that hole. But she said, I need to tell the testimony that I saw. I'm going to tell the truth. And she did. Let's talk about Val. Am I right? Still 4 people, right? Still the same descriptions. Her testimony last week was inconsistent with every single time she had given testimony previously. Every single time that she talked to the officer on the scene. She talked to detectives later on. She talked to me in a deposition a year and a half later. She was 100% certain, her words, not mine. The driver was not the shooter. The driver was not the shooter. That Thomas ran in front of her to the 2 people, to Kayla and the person, her assailant, that were struggling. Who we think at this point is JD. And a shot rang out. Why would she change her testimony? She said she didn't talk to anyone about her testimony prior to taking the stand. Right? And then I sat down. Then Miss Wolf gets up. Oh, Miss Wright, come on, you remember. You and I had that conversation, right? We had that conversation. And upon your reflection, after these years, upon your reflection, the shooter is now the driver. Why would she claim that? When she walked through those doors, and she stood here, held up her hand, swore to tell the truth. She looked over at this table. She recognized a person that was there. She lost her friend, and she wants justice, and I don't blame her for that. Someone should pay. But here's the thing. Justice doesn't cut corners, and the right people should pay for this. And even though we don't have a burden to do so, the defense put on a case. And we made mention in the opening statement of the state's star witness, right? This co-defendant that was there. This testifying co-defendant, this flipping co-defendant, this rat, whatever you want to call him, right? He was bought at a high price. They bought this testimony at a high price. They cut him a deal of a lifetime. At his age, he will be out still in his 30s. If, big if, He's not caught lying on the stand. The state's star witness wasn't called by the state in their case in chief. Why? He's got too many lies. He can't keep it all straight. His account's all over the place. Once again, there aren't 4 people getting out of the car. There's just 2. There's just 2. Jaden's the shooter. No, Thomas is the shooter. Where's my gun? Where's my phone? Sends police on this wild goose chase. He gives one proffer, right, to the state after his arrest. They're like, you're lying. Try again. He does. He does give him a second proffer. But now it's made to fit. There's still only 2. Gets to keep his deal, protect Trey and JD. But if Sarah, right, because that's how they know each other, you're Chris and you know me as Sarah, right? If Sarah catches him in a lie, the deal is done. It's gone. He's got life. No takebacks. So worst case scenario, this guy can't hold it together on the stand, and we catch him in a lie, he goes away for life. But it gives us a chance to take a bite at Thomas Stein. It's a gamble by the state. But I put him on the stand. Because I could have just sat down and said nothing. You would have heard for neither of the defendants. Because in Florida, life means life. That's what Christopher Horn is looking at. He goes into a box, and after he's dead, he's carried out of a box. Do you remember his testimony, how random it was? Yeah, we saw a guy. We saw a dude over by the ATM. You were watching the ATM? Yeah. It was a guy in a yellow Mustang? I don't know what you're talking about. Well, how'd you see the ATM? I thought you were watching it. He's all over the place. Detective Les Landra tells him this. During one of his proffers, it's like, you know, these new cars, these newfangled cars, they are so highly technologically equipped, I can tell when the doors are opened. And that's when Christopher Horn says, oh, well, you see, when I was running back towards the car, I was so confused as to where I was sitting, I opened the back door first, closed it, and then opened the front door and got in. That's not a thing. Law enforcement are allowed to lie to people when they're talking to them about their statements. But this kid took it hook, line, and sinker. We talked about that timeline, right? He is arrested. His mom and his dad and his aunt are arrested for witness tampering. He gives a proffer. He gives a second proffer. The charges against his family are dropped. And now he's here testifying before you folks. You refer to Thomas Stein as sweet. I'm like, can you tell me what that means? He's like, you know what it means. Did he send you candy? No. He mail you a Christmas card? No. That means Thomas Stein is sweet, which is meaning Thomas Stein will do what I tell him to do. I can go to his house, smoke his cartridges, smoke his weed. He can give me a ride, drive me around. He'll do what I want him to do. within reason, right? Let's go try doors. Let's go see if some doors are open, some cars. We'll see if we can steal some change, see if we find something of value. That's the plan. Why do we need Christopher Horn? Why does the state need Christopher Horn to testify? Because there has to be one iota of a plan that was formulated between the two co-defendants and the other two boys that later got in the car. They have to answer, did Thomas know a robbery was about to go down? They have to answer that question. And the defense having no burden put it in front of them. So next we heard from Thomas Stein. And I'll have to admit, right? He's on the trial for his lifetime right now. He's got everything to lose in this case. But still, even with that grain of salt, he's more credible than Christopher Horn. His story makes more sense based upon the forensic evidence. I exposed Thomas to the cross-examination of Miss Wolf, right? Knowing she would get to question him. Because that in this case, in particular, you have to hear it from the horse's mouth. And the advice was, you have to be truthful about everything. The ugly truth, yeah, he sells weed through telegraph. He even charges his friends, right? Because he buys the weed, he sells it for the same price, right? And he gets to keep a piece for himself. He didn't have to, but he still had to testify how he got rid of the gun. Because you, as the jury, would want to know why and how it happened. This is based upon the advice of Horn Sr. He admits to hanging out with Christopher Horn Jr. He advises that the plan was to try door handles, so they start driving around. What do kids do on a Friday night or on a Sunday night at the start of spring break? Everything's closed. What are you going to do? You drive around. You just drive around. There's a gun in the car. Because Christopher Horn likes to pretend they're hard. But the tenor, right? The atmosphere in that car changes when these two guys got in at that church at North Fort Myers. They're just driving around. You heard Thomas say it felt awkward, like I didn't really belong there. Like these three guys knew each other, but not me. So let's look at this. What indicia, what facts indicate Stein knew the plan to rob these girls? Because that's the ultimate question that we have to answer. If he knew about the plan, then he's involved in the robbery. He's involved in the robbery, he's guilty of felony murder. But if he doesn't know about the plan to rob, and he's not involved in the attempted robbery, then he's not guilty of felony murder. So Tom and these three guys, they're driving down the street, and they see three pretty girls walking. And they're going to do what other teenage boys do. They slow down. They check them out. Thomas, in his gullibility and his stupidity, right? This is the plan, to rob them. In his stupidity, he's just looking at them, right? Staring at them. What's up, ladies? They're giggling at him. He's not wearing a mask. These other boys are in the shadows. He's got a cell phone on him, right? Obviously, if you're going to go and commit crimes, you should have your cell phone on you. He goes live on Instagram that night. What's up, Kalina? What's good, JJ? He hears JD say, hey, I think I know one of them. Turn around. So he turns around. He flashes his lights at him. Hey, over here. I want to talk to you. Stops the car in front of him. And the doors burst open. He opens his door too. Like, what's going on? People are pulling down ski masks, running up with guns, and he's standing there. What's happening right now? He sees the struggle between Kayla and her assailant, JD. He's not claiming to be a hero, but he just wants to separate them because there's a struggle going on. Gunshot rings off. This is consistent with the true testimony of Emma Wright, who testified that she saw Thomas run from the driver's side in front of her, in front of the vehicle, to Kayla and her assailant. This is my last chance that I have to have a word with you. The state gets to get up here and try to rebut everything that I'm telling you now. But I need you to keep this in mind. Is there a reasonable doubt that Thomas Stein in this case didn't know that a robbery was going down? Based upon what we absolutely know to be true. That he slowed down, showed his face, not wearing a mask, had his phone with him, stood at the door, tried to intercede. Is this the case where Thomas Stein was actually involved in the planning of this robbery, which resulted in a murder? Or is this like Mr. O'Brien's case, where star athlete was just the wrong place with the wrong people? The judge will tell you that mere presence is not enough. Once again, Ms. Miller gets a chance to get up here, and she may say it doesn't matter, it's 2 or 4. But it does matter. Because he was definitely there, and he was definitely driving. There was definitely a robbery. The question is, did he know? And at this point, we have conflicts in the evidence between Christopher Horn's testimony, which is highly questionable. Even taking Thomas's testimony out of it, just look at the facts. Just look at the facts. Once again, justice demands that you find a just verdict in this case that's held in place by the evidence and the law that supports it. The right people have to answer for this tragedy. Thank you.
All right. Is everybody in the jury doing okay? Okay. Just move.
Ladies and gentlemen of the jury, Kayla, Emma, and Luann were the victims on March 17th, 2024. Don't be fooled by Thomas Stein's testimony. Don't be fooled by the lies he told you. He was not a victim. He was going out by his own admission to commit crimes that night. He told you he and Christopher Horn Jr. were going out to go car hopping. They were going to break into cars and steal whatever valuables they could find. They were not going to choir practice at church. They were not going to see the movies like our victims were. They were going to commit crimes. And at some point, their decision to just break into cars changed, into robbing someone, change into putting firearms in people's faces to get more and to get whatever they could get. Because it's more likely that a person has valuables on them than in their car. And you as jurors don't have to decide when that plan was formed. It could have been formed early in the night. It could have been formed when those calls were made between Christopher Horn and Thomas Stein and arranged for... It could have been made when they arranged to be picked up. When Christopher Horn sent that message of his address, they could have already had the plan to commit robberies. You don't have to decide that. Maybe the plan for Thomas Stein to engage in a robbery was when those doors opened. But what we know is that he participated in that attempted robbery of those girls. He may not have decided to rob 3 girls that night, but when he stopped his car and shined his lights on them and got and hopped out of that car as fast as he could, all while yelling, "Give us your shit," he was attempting to rob them. He played a role. He was not going there to hit on the girls. He didn't roll by them and roll down the windows while they all leaned out and said, hey girls, what's up? Can we get your number? No, he rolled slowly past them, drove by, drove around, and drove back to them where he quickly pulled his car at them, shined his lights, and they all hopped out of the car. And when I say they, it could have been 2, it could have been 4. It depends on whose testimony you believe. The victims say there were 4. And the state never told them to say otherwise. What do you know about the number of people involved in this case? What you know is that Detective La Salandra turned over every stone to try to put anybody and everybody on scene that night. He did tower dumps, and if you recall, the only people whose numbers hit all 3 of those towers were the 2 defendants charged for felony murder. And if you recall, there were only them and one other person who hit the church tower and the crime scene tower. And the 3rd person was an Uber Eats delivery driver who had nothing to do with this crime. But what you remember, Detective La Salandra told you, if we could put anybody else at that scene, if any other information came forward, he would investigate it, and if he could prove that they also assisted in a robbery, they also could be indicted for first-degree felony murder. Ladies and gentlemen, you don't have to decide. You don't have to decide. Remember what we talked about in voir dire. The state has elements to prove, and my co-counsel went over the 3 elements to prove first-degree felony murder. We don't have to prove whether there were 2 or 4. In fact, if you had to go back there and decide how many people were involved with this robbery, you might have a reasonable doubt because there's conflicting testimony about how many people were involved. But there's not conflicting testimony that Thomas Stein was a participant in that robbery. And I'd like you to remember that Christopher Horn was never called by the state. And why is that significant? Because he's not a star witness. He had no evidence that the state needed to prove the charges against Thomas Stein. We didn't call him. You heard from all the state's witnesses, and then the state said, we rest, and we sat down. And the defense elected to call him. And as far as witness testimony, you can believe any, all of, some of, or none of the witnesses' testimony. You get to decide what you believe Christopher Horn was telling you, whether it was true or not. You get to decide how much of Thomas Stein's testimony to believe. And I would suggest to you that they're both lying. They're both giving information that's not supported by the evidence in this case. Defense talked about principle, that the defendant intended the crime to occur. He intended the crime of attempted robbery to occur when he armed himself, when he armed his co-defendant. He gave him the firearm. He gave him that 1911. And Madam Clerk, I'm going to ask that you pull that exhibit with the firearm of Jaden Fernandez holding the firearm. Thank you. And I'm going to get back to that in a moment. there's numerous parts of the evidence that you can look to decide whether the defendant intended for the crime to occur. Both girls testified that the car doors flew open and everybody jumped out, and that Thomas Stein immediately went toward Kayla. He didn't jump out confused, shocked about, oh my God, I didn't know that there was going to be an attempted robbery. I thought we were just getting the girls' numbers. That's a preposterous thing to believe. That's a forced doubt.
Hold on 1 second. I'm sorry.
Denigrating the defense, Judge.
Overruled.
It's preposterous to believe Thomas Stein's testimony that they were there to get girls' numbers. These men were armed with weapons, with firearms. They had masks, and they obviously had to have a conversation about what they were doing when those doors came open. To believe that Thomas was just this innocent, oblivious person going from car hopping to getting girls' numbers is a forced doubt. Defense made a deal about the testimony from Amy Schober, and she talked about the firearms and the Glock 27, and I would argue that's a very, very significant piece of evidence. And Amy Schober did testing, and she used Photoshop, but what did she tell you? She didn't alter or try to change the image. She locked it in so that she could make it the same size, scale-wise, to match the autopsy photo. And you saw the autopsy photo, the scale that showed that what they used to take those photographs, and then she used that same scale to make the firearm image fit the same scale as the wound. Now, defense said, well, didn't do a very good job. She didn't look at the 1911. Well, you can look at the 1911, and you can see there's no lines on that firearm. There's no markings on the slide of that firearm that could be tested or compared with the wound. And not only that, you heard from both victims that the person with the red hooded sweatshirt and the white lettering that we know now to be Christopher Horn Jr., he didn't fire that gun. He had it pointed toward them and he never fired it. And then, by Christopher Horn's testimony, he also indicated to you that he didn't fire the gun. And then Thomas Stein also said that Christopher Horn didn't fire the gun. So that leaves the Glock 27. And that's why, because of the way the evidence stacked, where we have Thomas Stein in a video with the Glock 27 belonging to his mom, that firearm was used to do an overlay to see if that would be consistent with the injuries near the bullet wound. And what else do we know about that firearm? Because Stein told you two completely different stories. First he says, oh, I don't know where the Glock is when my co-counsel was asking him on cross-examination. I thought it was in my mom's safe. And then 2 minutes later when defense gets back up, he goes, oh yeah, I sold it. So you're telling me someone who didn't have any participation, who was the hero who tried to save Kayla's life that night, burns his clothes and gets rid of his mother's firearm by selling it within 48 hours. The reason that he and Christopher Horn got rid of the firearms after the murder is because they were used in the attempted robbery. They didn't get rid of them just for fun. They got rid of them because they're pieces of evidence in this case. And Jessica Stein told you, I have no idea where the gun went. It was no longer in my house. And you heard Amy Schober say, the gun wasn't found. And now, today, Thomas Stein says, oh, yeah, I sold it. I sold it on the same platform I used to sell all my drugs. Jaden's testimony, he talks about the statement that Christopher Horn made about robbing a Chico. Recall, the door was open when he's saying this, and he sees this gun. Jaden sees this gun. This is Jaden, but he sees this same gun that Thomas Stein stores at his house because the owner of the gun is in custody, and the owner of the gun is on probation and can't have a gun, so Thomas Stein stores it for his friend. that gun was in Christopher Horn's hand when he's saying, let's go rob a Chico. And defense wants to suggest to you that Thomas Stein never heard that, had no idea, didn't know anything about what they were going to do, that they were going to do anything bad that night. Defense went past Jessica Stein quickly because Jessica Stein is a problem for the defense. Jessica Stein testified that that night she went into her room, so she didn't know what was going on. And she testified to you that prior to her going into her room, she saw Christopher Horn and she saw her son. Those are the only two people in her home that she saw. The only other person in this case that she saw that day was Jaden Fernandez when they went to the beach. She also stated that she doesn't know where the gun is. She also stated that what does she do with the car used in the murder? She gets rid of it the next day. What else does she tell you? She went to a park, not with JD or Trey. She goes to the park with her son, with Christopher Horn Jr., and with Christopher Horn's family to talk about how to get rid of the evidence. Both of those boys were involved, and the families got together because they needed a plan at how to avoid detection, how to avoid arrest. Jessica Stein knew what was going on, and she knew she had to assist in keeping her son from getting arrested. None of the elements that you'll see the state has to prove rely on Christopher Horn's testimony, which is why we didn't call him. We didn't need him as a witness in the case. Defense wants you to get sidetracked about the deal. And we know he wasn't a star witness. The state didn't call him. You have all the evidence you need to know that the defendant participated in a robbery. We also have Luann's testimony. And the defense mischaracterized her testimony that the state told her to say there's only two people. That never was a testimony. She was adamant from the beginning that there were four people. And it was frustrating because the detective was never able to put any other additional people on the scene. She came up and she told you the truth, and she told you what she remembers. The state doesn't have to prove how many people were there. I would suggest that the defense has tried to paint out Thomas Stein as a victim, that he's the one that's being used, that he has this nice house and nice family and everything he needs and everything's provided, and that Christopher Horn comes along and he's thuggish and his friends are thuggish, and because of that, they use Thomas Stein. And I would suggest, the evidence suggests otherwise. Thomas wasn't the victim of peer pressure. He's the drug dealer. He's the one with the guns. He's the one with the car. He's the one with the mom that permitted him to smoke weed and play with guns. He's the bad influence. The defendant wants to make you think that getting rid of the evidence was Horn's idea. They both burned their clothes. They both got rid of the guns. And Stein couldn't keep his story straight about the guns from one moment to the next. This isn't a popularity contest. This isn't about who has money and who doesn't and who has a better family. This is about whether Thomas Stein, the only defendant sitting before you today, did some act or said something that was intended to and did incite, cause, encourage, assist, or advise the other persons or persons to actually commit, to attempt, or commit the crime. You saw the videos of Thomas Stein right before the murder. That wasn't a guy who was on his way to pick up chicks. Guns and masks are not how you pick up chicks. He didn't transition from car hopping that night to trying to pick up girls. Even even if you feel that Christopher Horn Jr. is worse or seems like more of a criminal, it doesn't matter. Even if you think Thomas Stein was a follower that night, it doesn't matter. Not having the idea for the crime, not coming up with a plan, doesn't give you a pass. Nowhere in the instructions will you see that the state has to prove whose idea it was or when the idea came about. When he got out of that car, armed with the gun, and they were saying, give us your stuff, give us your shit, he was attempting to commit a robbery. You heard that it will be the judge's job to provide a sentence if the defendant is found guilty in this case. And if at any point you're in the back of those deliberation rooms and you feel sorry for the defendant or are concerned what might happen to him, you have already done your job. You have already found that he is guilty. Your job is to decide whether the state proved the charges beyond and to the exclusion of every reasonable doubt, and it's the judge's job to impose the sentence. The only people providing assistance that night were the people you saw here in court. Luann sat trying to stop the blood from Kayla, trying to stop her from bleeding out on the scene. She provided assistance. You heard from Emma. She provided assistance when she called 911. And you heard from Officers Vega. He and Houlihan were there first on scene and provided assistance to Kayla. And you heard from the officer, the lieutenant that went to Gulf Coast Hospital. And there were at least 20 people surrounding her, fighting for Kayla's life. Those were the people on March 17th that provided assistance to Kayla. Thomas Stein was not trying to provide assistance and break something up. He fled the scene as soon as she was shot, never to look back and only to work on getting rid of the evidence to make sure that he wasn't caught for the actions that he and the people that he was with did that night. Thomas Stein is not a victim in this case. Christopher Horn is not a victim. The victims are Emma Wright, Luann Deja, and Kayla Rincon-Miller. And we would ask that you find Thomas Stein guilty for his participation in the attempted robbery of the girls that night. And as a result of his behavior, as a result of committing a dangerous crime of robbery, he's guilty for everything that happened, whether you believe he pulled that trigger or not. And so I'd ask that you hold Thomas Stein accountable for attempting to rob those girls. And in the course of that, the death of Kayla for first-degree felony murder and the attempted robberies of Kayla, Emma, and Luann. Thank you.
All right. So, ladies and gentlemen of the jury, I have, as been told to you, a fairly lengthy set of instructions to read to you. It is 1 o'clock. You have the option of me releasing you to let you all go to lunch and come back, and I can read the instructions to you. Or, if you wish, I can take a short recess, let you go back to the jury room and order lunch to be delivered to you later and have you come right back out and read the instructions to you. I know you've been sitting here for a long time this morning, so my inclination would be to let you all go to lunch and then come back, and I'd read the instructions to you. Is everybody okay with that? Okay. All right. Then it's very, very important you remember my instructions. Don't look up anything. Don't discuss anything, even among yourselves, about this case or your jury service, and don't discuss that with anyone else. Does everybody understand the instructions? All right. I'm going to release you to lunch then. It's 1 o'clock. Please be back here by 2 o'clock.
All right.
Just leave your notepads here. All right. let the record reflect the jury's exited the courtroom. I just wanted to give them that option to determine whether or not they wanted to proceed now or go ahead and go to lunch. I think they all seemed to be nodding in assent. They wanted to go to lunch and then come back. So we will be in recess until 2 o'clock. Is there anything else the court needs to address? No. Okay. All right. We'll see you at 2 o'clock.
Okay, squad. Well, we've now heard the entire case. We've heard what the jurors heard today. I'm going to pull this poll down and we'll put up a new poll. I want to know if you think that they have proven first-degree murder. I mean, I don't think that there's any doubt that they've proven second-degree murder. But the deal here is Thomas going to go away forever, or is he going to get a chance at parole? Which is the deal that Christopher Horn has. I don't know. What do you think? And first-degree murder in this case, because this is a felony murder case, is he fired that gun. He's the person who shot Kayla Rincon-Miller. So remember, all you have to do with the poll is that you vote by posting 1, 2, or 3 in the chat. 1 being yes, 2 being no, and 3 being not sure. We'll do another poll when the jury's coming back for deliberation, after deliberation. Or I mean, when the jury goes to deliberation, we'll do a poll about if you think what they're going to find him guilty of. I don't know. That defense attorney pissed me off to no end. You know, oh, poor gullible little Tommy. He didn't even know they were going to do a robbery, guys. Are you kidding me? As the state said, he's the drug dealer. He's the guy with the guns. He's the guy with the car. Like, what? And to imply that somehow he wasn't even a part of any of this is so ridiculous. And honestly treats the jury like they are idiots, which we know they're not. They've been watching this. Yeah, it was good. The rebuttal was really good. I think the rebuttal was the best part. But you know, it usually is. The state's closing was all about the jury instructions and all of the charges. And, you know, what the jury needed to find, which is important because they need to hear that. They need to hear that from the perspective of the prosecutor. They're going to hear it from the judge, but there's no explanation from the judge. So I do think that that's important, but to really lay it out and put it right on the table, that rebuttal did that. Right, Irene says, I did like the rebuttal saying he was the bad influence. He was the guy that was dealing drugs on Telegram, advertising on Instagram to go to his Telegram account where they could order the drugs. I mean, come on. Little Tommy was just it, and Thomas himself wanted us all to think that he was the hero, guys. He tried to save Kayla, don't you know? He was not the bad guy here. Oh my God, this little shit. He was so slick and spoke not like the young man that he is. One of the big differences for me was that Christopher Horn spoke the way that he naturally speaks, very clearly. I didn't think that Thomas Stein spoke the way he naturally speaks at all. He spoke the way he was told to speak by his defense attorneys. Yeah, right. Sweet. They did do it a little bit differently, that she did the rebuttal with all of the evidence at the end instead of the beginning closing. But the thing is, that's the last thing the jury sees. So Irene says, although I'm at a 3, I'm at a 95%, almost to 1. Yeah, he was totally coached, wasn't he? His testimony just made me want to punch him. All right, so it looks like we're at 100% ones on the poll. Remember, if you're going to vote, all you have to do is post 1, 2, or 3 in the chat, 1 being yes, 2 being no, and 3 being not sure on whether or not the state has proven first-degree murder. I was not sure. I think I'm going to go to 1 now. And, I mean, we don't know exactly what this jury heard and how they're going to look at it. But to think that Thomas was the gullible one in this situation, there's just no way that's the case. Running his little enterprise out of his house, got a sweet deal where mom doesn't care if he and his friends smoke weed on her property as minors. I mean, the fact that Jessica Stein hasn't had criminal charges herself over this is pretty stunning. Pretty stunning to me. She has definitely proven herself to be a terrible parent. And I know there have been a lot of accusations made toward the Horns as well. In court is that they were initially charged with witness tampering, evidence tampering, that kind of thing. And after the prosecutor heard a recorded conversation between them and Jessica Stein, they dropped all the charges. And they can't share that recording because it was an illegal recording, but they can say to the judge and to the defense, the jury didn't hear this, that there was no way in hell ethically that they would charge the Horns after what they heard in the conversation with Jessica Stein. It says a lot, doesn't it? Yeah, Rosanna says, I feel like Thomas saw Chris as a stereotype he could use as the fall guy for whatever shenanigans. Their friendship seems very one-sided to me. Yes, I was thinking the same thing. He's a convenient guy to have around because he can just foist whatever's happened, just make him the fall guy for whatever they're up to. I felt that way too. I don't know. The whole thing, this whole defense is just wild to me, to think that the jury is going to buy the idea that Thomas wasn't involved at all when he was the driver, the supplier of the guns, and the drug dealer. Proven, stated by him on the stand that he would then be, guys, he's just a good kid. He tried to help. He burned his clothes and he got rid of the gun. Right. The jury didn't hear why they dropped charges on the parents, but they also don't know that there are charges against the parents. So, yeah. Yeah, so helpful, right? Crazy. Okay. So I'm going to go see, we're zooming ahead because remember, we're behind. I'm going to go see if their lunch break is over and we can go to jury instructions yet, or if not, we'll be pretty close to that, I think. So I'm going to pop off from here. and go do that. But I just want to say thank you for joining me for this trial. This has been pretty interesting. Just watching the way that all this has been handled, it's been really wild. I'm amazed at both attorneys that they do not do anything that judge tells them to do. I think he's probably so sick of these dummies by now, waiting for them to be ready with everything constantly and them needing more time for everything. Very annoying. But anyway, thanks for joining me. And pretty quickly here, we're going to be on jury watch. And then I'll put up a new poll and we'll talk about how long we think the jury is going to take. And also, what do we think the verdict is going to be? Alrighty. Okay. Let's go see if we can jump in on jury instructions.
right. Good afternoon. Please be seated. All right, let the record reflect the state's president, defense counsel, and the defendant are present. We have all the jurors back.
Yes, Your Honor.
All right, so we're ready to have them come back in, and I'll read the jury instructions. State?
Yes, sir.
Okay, and defense. Oh, thank you. All right.
You good?
All right, let's bring them in.
Jurors entry.
All right, good afternoon. Please be seated. All right. So, ladies and gentlemen of the jury, I'm about to read the instructions to you. Before I do that, let me just, by a show of hands, was anyone on the jury not able to follow the court's instructions about doing any research, looking up anything, or discussing anything about their service as a juror on the case? Seeing your hands, we're ready to proceed. Now, these instructions are 71 pages long. They're not all full pages, but it's going to take some time. If at some time, if somebody needs a break or anything like that, let me know. If I'll be trying to read and look up at you at different times. But if for some reason I don't see you raise your hand, let Mike know, and he'll let me know if anybody needs a break. Okay? And I'll let you know if I need a break. All right? All right. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Statement of charge. Thomas Stein, the defendant in this case, has been accused of the crimes of first-degree felony murder and 3 counts of attempted robbery. Introduction to homicide. And also, before I go on, I'm reading these to you. You will get a copy of these to go back with you as well. All right? Introduction to homicide. Thomas Stein is accused of first-degree felony murder. First-degree felony murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable homicide or that was committed by the justifiable use of deadly force is lawful. If you find Kayla Rincon-Miller was killed by Thomas Stein, you will then consider the circumstances surrounding the killing and deciding if the killing was second-degree murder or manslaughter, or whether the killing was excusable homicide or resulted from the justifiable use of deadly force. Justifiable homicide. The use of deadly force to kill a human being is justifiable homicide and therefore lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in or upon any dwelling house in which the defendant was at the time of the killing. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means harm that is more than slight, trivial, minor, or moderate. Excusable homicide. The killing of a human being is excusable homicide and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by an accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Count 1, first-degree felony murder. To prove the crime of first-degree felony murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Kayla Christina Rincon-Miller is dead. 2, while engaged in the attempt to commit a robbery, Thomas Stein or Thomas Stein's accomplice caused the death of Kayla Christina Rincon-Miller. 3, Thomas Stein was the person who actually killed Kayla Christina Rincon-Miller, or Kayla Christina Rincon-Miller was killed by a person other than Thomas Stein, but both Thomas Stein and the person who killed Christina Rincon-Miller were principals in the commission of attempted robbery. To convict the defendant of first-degree felony murder, it is not necessary for the state to prove the defendant had a premeditated design or an intent to kill. Robbery is defined as 1, Thomas Stein took a purse from the person or custody of Kayla Christina Rincon-Miller. 2, force, violence, assault, or putting in fear was used in the course of the taking. 3, the property was of some value. 4, the taking was with the intent to permanently or temporarily deprive Kayla Christina Rincon-Miller of her right to the property or any benefit from it, or appropriate the property of Kayla Christina Rincon-Miller to her own use or to the use of any person not entitled to it. Attempt is defined as 1, Thomas Stein intended to commit the crime of robbery. 2, Thomas Stein committed an overt act toward the commission of a robbery that went beyond mere preparation. 3, Thomas Stein failed to complete the robbery. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. It is not necessary for a principal to know every detail of how a first-degree felony murder will be committed as long as the principal intended the first-degree felony murder to occur and did some act or said something that was intended to help and did help the first-degree felony murder to occur. To be found guilty of robbery or attempted robbery with a firearm as a principal, it is not necessary for the state to prove a defendant knew another participant of the robbery or attempted robbery was armed. However, mere knowledge that the underlying attempted robbery is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to first-degree felony murder. If you find the defendant guilty of first-degree felony murder, you must also determine whether the state proved beyond a reasonable doubt that he actually killed, intended to kill, or attempted to kill Kayla Christina Rincon-Miller. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of first-degree felony murder was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of first-degree felony murder occurred, that in and of itself does not establish that the first-degree felony murder was an independent act of another. If you find that the first-degree felony murder was an independent act of another person, then you should find Thomas Stein not guilty of the crime of first-degree felony murder. Aggravation of first-degree felony murder by carrying, displaying, or using a firearm. If you find that Thomas Stein committed first-degree felony murder You must then determine whether it has been proven beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, or used a firearm. A firearm is defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. Possession of a firearm and discharge causing death. If you find that Thomas Stein committed first-degree felony murder, you must then determine whether it has been proven beyond a reasonable doubt that 1. During the commission of the crime, Thomas Stein actually possessed a firearm. 2. During the commission of the crime, Thomas Stein discharged a firearm. And 3. During the commission of the crime, Thomas Stein discharged a firearm and in doing so caused the death of Kayla Christina Rincon-Miller. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Lesser included crimes. If the evidence does not convince you that the defendant committed the main crimes of which he is accused, there may be sufficient evidence that he committed a lesser included crime. In other words, if you decide the main accusation has not been proved beyond a reasonable doubt that the defendant is guilty of, in other words, if you decide the main accusation has not been proved beyond a reasonable doubt that the defendant is guilty of a lesser included crime, the lesser, I'm not sure that reads right. The lesser included crimes of first-degree felony murder are second-degree murder and manslaughter. Count 1, lesser included crime, second-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Kayla Christina Rincon-Miller is dead. 2, the death was caused by the criminal act of Thomas Stein. 3, there was an unlawful killing of Kayla Christina Rincon-Miller by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. To convict of second-degree murder, it is not necessary for the state to prove that the defendant had an intent to cause death. If you find Thomas Stein guilty of second-degree murder, you must also determine whether the state proved beyond a reasonable doubt that he actually killed, intended to kill, or attempted to kill Kayla Christina Rincon-Miller. Aggravation of second-degree murder by carrying, displaying, or using a firearm. If you find that Thomas Stein committed second-degree murder, you must then determine whether it has been proven beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, or used a firearm. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. Possession of a firearm and discharge causing death. If you find that Thomas Stein committed second-degree murder, you must then determine whether it has proven beyond a reasonable doubt that 1. During the commission of the crime, Thomas Stein actually possessed a firearm. 2. During the commission of the crime, Thomas Stein discharged a firearm. And 3. During the commission of the crime, Thomas Stein discharged a firearm, and in doing so, caused the death of Kayla Christina Rincon-Miller. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means the defendant A. carried a firearm on his person, or B. had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1. The defendant intended the crime to occur, and 2. The defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. For second-degree murder, it is not necessary for the state to prove the defendant intended the death of Kayla Christina Rincon-Miller. It is not necessary for a principal to know every detail of how a second-degree murder will be committed as long as the principal intended the second-degree murder to occur and did some act or said something that was intended to help and did help the second-degree murder occur. However, mere knowledge that the underlying attempted robbery is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to second-degree murder. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of second-degree murder was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1. Which the defendant did not intend to occur, and 2. In which the defendant did not participate, and 3. Which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of second-degree murder occurred, that in and of itself does not establish that the second-degree murder was an independent act of another. If you find that the second-degree murder was an independent act of another person, then you should find Thomas Stein not guilty of the crime of second-degree murder. Count 1, lesser included crime, manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1. Kayla Christina Rincon-Miller is dead. 2. Thomas Stein intentionally committed an act or acts that caused the death of Kayla Christina Rincon-Miller. Every person has the duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. To convict of manslaughter, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1. The defendant intended the crime to occur, and 2. The defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying manslaughter is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to manslaughter. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of manslaughter was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1. Which the defendant did not intend to occur, and 2. In which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find that the defendant was not present when the crime of manslaughter occurred, in and of itself does not establish that the manslaughter was an independent act of another. If you find that the manslaughter was an independent act of another person, then you should find Thomas Stein not guilty of the crime of manslaughter. Aggravation of manslaughter by carrying, displaying, or using a firearm. If you find that Thomas Stein committed manslaughter, you must then determine whether it has been proven beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, or used a firearm. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler, firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. Count 2, attempted robbery. Kayla Christina Rincon-Miller. To prove Thomas Stein attempted to commit the crime of robbery, the state must prove the following 3 elements beyond a reasonable doubt. 1. Thomas Stein intended to commit the crime of robbery. 2. Thomas Stein committed an overt act toward the commission of robbery that went beyond mere preparation. 3. Thomas Stein failed to complete the robbery. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. 1. Thomas Stein took a purse from the person or custody of Kayla Christina Rincon-Miller. 2. Force, violence, assault, or putting in fear was used in the course of the taking. 3. The property taken was of some value. 4. The taking was with the intent to permanently or temporarily deprive Kayla Christina Rincon-Miller of her right to the property or any benefit from it, or appropriate the property of Kayla Christina Rincon-Miller to her own use or to the use of any other person not entitled to it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim. When it appears the person making the threat has the ability to carry out the threat, and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. In the course of the taking means the act occurred prior to, contemporaneous with, or subsequent to the taking of the property, and that the act and the taking of the property constitute a continuous series of acts or events. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of a victim. It is sufficient if the property taken is under the custody of the victim, so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if, in the course of the committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find the defendant carried a firearm in the course of committing the robbery, you should find him guilty of robbery with a firearm. A firearm means any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find that the defendant carried a weapon that was not a firearm in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. If you find the defendant carried no firearm or weapon in the course of committing the robbery, but did commit the robbery, you should find him guilty only of robbery. Possession of a firearm. If you find that Thomas Stein committed attempted robbery, you must then determine whether it has been proven beyond a reasonable doubt that during the commission of the crime, he actually possessed a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying attempted robbery is being committed and the mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to attempted robbery. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime attempted robbery was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of attempted robbery occurred, that in and of itself does not establish that the attempted robbery was not an independent act of another, or was an independent act of another. If you find that the attempted robbery was an independent act of another person, then you should find Thomas Stein not guilty of the crime of attempted robbery. Lesser included crimes. The evidence does not convince you that the defendant committed the main crime of which he is accused, and may be sufficient evidence that he committed a lesser included crime. In other words, if you decide the main accusation has not been proved beyond a reasonable doubt, you will need to decide if the state proved beyond a reasonable doubt that the defendant is guilty of a lesser included crime. The lesser included crime of attempted robbery are theft and assault. Count 2, lesser included crime, theft. To prove the crime of theft, the state must prove the following 2 elements beyond a reasonable doubt. 1, Thomas Stein knowingly and unlawfully endeavored to obtain or use the purse or property of Kayla Christina Rincon-Miller. 2, he did so with intent to either temporarily or permanently deprive Kayla Christina Rincon-Miller of her right to the property or any benefit from it. Proof of possession of recently stolen property, unless satisfactorily explained, gives rise to an inference that the person in possession of the property knew or should have known that the property had been stolen. Obtains or uses means any manner or taking or exercising control over property. Endeavor means to attempt or try. Property means anything of value. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying theft is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to theft. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of theft was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. We find the defendant was not present when the crime of theft occurred. That in and of itself does not establish that the theft was an independent act of another. We find that the theft was an independent act of another person, then you should find Thomas Stein not guilty of the crime of theft. Count 2, lesser included crime, assault. To prove the crime of assault, the state must prove the following 3 elements beyond a reasonable doubt. 1, Thomas Stein intentionally and unlawfully threatened, either by word or act, to do violence to Kayla Christina Rincon-Miller. 2, at the time, Thomas Stein appeared to have the ability to carry out the threat. 3, the act of Thomas Stein created in the mind of Kayla Christina Rincon-Miller a well-founded fear that violence was about to take place. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt. 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying assault is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to assault. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of assault was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of assault occurred, that in and of itself does not establish that the assault was an independent act of another. If you find that the assault was an independent act of another person, then you should find Thomas Stein not guilty of the crime of assault. Count 3, attempted robbery, Luann Dejay. To prove Thomas Stein attempted to commit the crime of robbery, the state must prove the following 3 elements beyond a reasonable doubt. 1, Thomas Stein intended to commit the crime of robbery. 2, Thomas Stein committed an overt act toward the commission of robbery that went beyond mere preparation. 3, Thomas Stein failed to complete the robbery. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. 1, Thomas Stein took a purse from the person or custody of Luann Dejay. 2, force, violence, assault, or putting in fear was used in the course of the taking. 3, the property taken was of some value. 4, the taking was with the intent to permanently or temporarily deprive Luann Dejay of her right to the property or any benefit from it, or appropriate the property of Luann Dejay to her own use or to the use of any person not entitled to it. An assault is an intentional and unlawful threat, either by word or act, to do violence to the victim when it appears the person making the threat has the ability to carry out the threat. and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. In the course of the taking means that the act occurred prior to, contemporaneous with, or subsequent to the taking of the property, and that the act and the taking of the property constitute a continuous series of acts or events. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to making the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of a victim. It is sufficient if the property taken is under the custody of a victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if, in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find the defendant carried a firearm in the course of committing the robbery, you should find him guilty of robbery with a firearm. A firearm means any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find the defendant carried a weapon that was not a firearm in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. If you find the defendant carried no firearm or weapon in the course of committing the robbery, but did commit the robbery, you should find him guilty only of robbery. Possession of the firearm. If you find that Thomas Stein committed attempted robbery, you must then determine whether it's been proven beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that an underlying attempted robbery is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to attempted robbery. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of attempted robbery was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present during the crime of attempted robbery occurred, That in and of itself does not establish that the attempted robbery was an independent act of another. If you find that the attempted robbery was an independent act of another person, then you should find Thomas Stein not guilty of the crime of attempted robbery. Lesser included crimes. If the evidence does not convince you that the defendant committed the main crime of which he is accused, there may be sufficient evidence that he committed a lesser included crime. In other words, if you decide the main accusation has not been proved beyond a reasonable doubt, you will need to decide and the state prove beyond a reasonable doubt that the defendant is guilty of a lesser included crime. The lesser included crime of attempted robbery are theft and assault. Count 3, lesser included crime, theft. To prove the crime of theft, the state must prove the following two elements beyond a reasonable doubt. 1. Thomas Stein knowingly and unlawfully endeavored to obtain or use the purse or property of Luann Dejay. 2. He did so with intent to either temporarily or permanently deprive Luann Dejay of her right to the property or any benefit from it. Proof of possession of recently stolen property, unless satisfactorily explained, gives rise to an inference that the person in possession of the property knew or should have known that the property had been stolen. Obtains or uses means any manner of taking or exercising control over property. Endeavor means to try, attempt, or try. Property means anything of value. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that it did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying theft is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to theft. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of theft was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of theft occurred, that in and of itself does not establish that the theft was an independent act of another. If you find that the theft was an independent act of another person, then you should find Thomas Stein not guilty of the crime of theft. Count 3, lesser included crime, assault. To prove the crime of assault, the state must prove the following 3 elements beyond a reasonable doubt. 1, Thomas Stein intentionally and unlawfully threatened, either by word or act, to do violence to Luann Dejay. 2, at the time, Thomas Stein appeared to have the ability to carry out the threat. 3, the act of Thomas Stein created in the mind of Luann Dejay a well-founded fear that the violence was about to take place. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying assault is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to assault. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of assault was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of assault occurred, that in and of itself does not establish that the assault was an independent act of another. If you find that the assault was an independent act of another person, then you should find Thomas Stein not guilty of the crime of assault. Count 4, attempted robbery, Emma Wright. To prove Thomas Stein attempted to commit the crime of robbery, the state must prove the following 3 elements beyond a reasonable doubt. 1, Thomas Stein intended to commit the crime of robbery. 2, Thomas Stein committed an overt act toward the commission of robbery that went beyond mere preparation. 3, Thomas Stein failed to complete the robbery. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward the completing the crime. To prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. 1, Thomas Stein took a purse from the person or custody of Emma Wright. 2, force, violence, assault, or putting in fear was used in the course of the taking. 3, the property taken was of some value. 4, the taking was with the intent to permanently or temporarily deprive Emma Wright of her right to the property or any benefit from it, or appropriate the property of Emma Wright to her own use or to the use of any other person not entitled to it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim. When it appears the person making the threat has the ability to carry out the threat, and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. In the course of the taking means the act occurred prior to, contemporaneous with, or subsequent to the taking of the property, and that the act and the taking of the property constitute a series of acts or events. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of a victim. It is sufficient if the property taken is under the custody of a victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if, in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find the defendant carried a firearm in the course of committing the robbery, you should find him guilty with a firearm. A firearm means any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find that the defendant carried a weapon that was not a firearm in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. If you find the defendant carried no firearm or weapon in the course of committing the robbery, but did commit the robbery, you should find him guilty only of robbery. Possession of a firearm. If you find that Thomas Stein committed attempted robbery, you must then determine whether it has been proven beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. If the defendant, principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying attempted robbery is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to attempted robbery. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of attempted robbery was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, when the defendant did not intend, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of attempted robbery occurred, that in and of itself does not establish the attempted robbery was an independent act of another. If you find that the attempted robbery was an independent act of another person, then you should find Thomas Stein not guilty of the crime of attempted robbery. Lesser included crimes. If the evidence does not convince you that the defendant committed the main crime of which he is accused, there may be sufficient evidence that he committed a lesser included crime. In other words, if you decide the main accusation has not been proved beyond a reasonable doubt, you will need to decide if the state proved beyond a reasonable doubt that the defendant is guilty of a lesser included crime. The lesser included crime of attempted robbery are theft and assault. Count 4, lesser included crime, theft. To prove the crime of theft, the state must prove the following 2 elements beyond a reasonable doubt. 1, Thomas Stein knowingly and unlawfully endeavored to obtain or use the purse or property of Emma Wright. 2, he did so with the intent to either temporarily or permanently deprive Emma Wright of her right to the property or any benefit from it. Proof of possession of recently stolen property, unless satisfactorily explained, gives rise to an inference that the person in possession of the property knew or should have known that the property had been stolen. Obtains or uses means any manner of taking or exercising control over property. Endeavor means to attempt or try. Property means anything of value. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying theft is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to theft. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of theft was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of theft occurred, that in and of itself does not establish that the theft was an independent act of another. If you find that the theft was an independent act of another person, then you should find Thomas Stein not guilty of the crime of theft. Count 4, lesser included crime. To prove the crime of assault, the state must prove the following 3 elements beyond a reasonable doubt. 1, Thomas Stein intentionally and unlawfully threatened, either by word or act, to do violence to Emma Wright. 2, At the time, Thomas Stein appeared to have the ability to carry out the threat. 3. The act of Thomas Stein created in the mind of Emma Wright a well-founded fear that the violence was about to take place. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying assault is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to assault. Independent act. If you find the crime alleged was committed, an issue in this case is whether the crime of assault was an independent act of another person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime, 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of assault occurred, that, in and of itself, does not establish that the assault was an independent act of another. If you find that the assault was an independent act of another person, then you should find Thomas Stein not guilty of the crime of assault. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction it is one which is not stable but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is the evidence introduced in this trial and do it alone that you will look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime hopes to gain more favorable treatment in his own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So, while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Rules for deliberation. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. And I'll show them to you and I'll read it to you. First is the verdict form. It reads, in the Circuit Court of the 20th Judicial Circuit in Fort Lee County, Florida, criminal action, State of Florida versus Thomas Stein, case number 24CF000272, verdict. We, the jury, find as follows as to the defendant in this case. Check only one box as to each count. Count 1, first-degree felony murder. A, the defendant is guilty of first-degree felony murder. B, the defendant is guilty of second-degree murder. C, the defendant is guilty of manslaughter. D, the defendant is not guilty. Count 2, attempted robbery, Kayla Rincon-Miller. A, the defendant is guilty of attempted robbery with a firearm. B, the defendant is guilty of attempted robbery with a weapon. C, the defendant is guilty of attempted robbery. D, the defendant is guilty of theft. E, the defendant is guilty of assault. F, the defendant is not guilty. Count 3, attempted robbery, Luann DeJay. A, the defendant is guilty of attempted robbery with a firearm. B, the defendant is guilty of attempted robbery with a weapon. C, the defendant is guilty of attempted robbery. D, the defendant is guilty of theft. E, the defendant is guilty of assault. F, the defendant is not guilty. Count 4, attempted robbery, Emma Wright. A, the defendant is guilty of attempted robbery with a firearm. B, the defendant is guilty of attempted robbery with a weapon. C, the defendant is guilty of attempted robbery. D, the defendant is guilty of theft. E, the defendant is guilty of assault. F, the defendant is not guilty. So say we all, place for the date, for the foreperson signature, and for the foreperson to print their name. And these are the special instructions I'll read to you. This is the first one. In the Circuit Court of the 20th Judicial Circuit in Fort Lee County, Florida, criminal action, State of Florida versus Thomas Stein, case number 24 CF 000272, special finding as to first-degree felony murder. If you found the defendant guilty of first-degree felony murder, you must then answer the following questions. 1. Do you unanimously find beyond a reasonable doubt that the defendant actually killed, intended to kill, or attempted to kill Kayla Christina Rincon-Miller? Yes, no. 2. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant personally carried, displayed, or used a firearm? Yes, no. 3. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant actually possessed a firearm? Yes, no. 4. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant discharged a firearm? Yes, no. 5. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant discharged a firearm and in doing so caused the death of Kayla Christina Rincon-Miller? Yes, no. So say we all, you have a place for the date, four-person signature, and the four-person to print their name. In the Circuit Court of the 20th Judicial Circuit and in Fort Lee County, Florida, criminal action, State of Florida versus Thomas Stein, case number 24 CF 272, special finding as to second-degree murder. If you found the defendant guilty of second-degree murder, you must then answer the following questions. 1. Do you unanimously find beyond a reasonable doubt that the defendant actually killed, intended to kill, or attempted to kill Kayla Christina Rincon-Miller? Yes, no. 2. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant personally carried, displayed, or used a firearm? Yes, no. 3. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant actually possessed a firearm? Yes, no. 4. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant discharged a firearm? Yes, no. 5. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant discharged a firearm and in doing so caused the death of Kayla Christina Rincon-Miller? Yes, no. So say we all, again, a place for the date, for the four-person signature, and four-person to print their name. In the Circuit Court of the 20th Judicial Circuit and in Fort Lee County, Florida, criminal action, State of Florida versus Thomas Stein, case number 24 CF 000272, special finding as to manslaughter. If you found the defendant guilty of manslaughter, you must then answer the following question. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant personally carried, displayed, or used a firearm? Yes, no. So say we all, in place for the date, four-person signature, and for the four-person to print their name. In the Circuit Court of the 20th Judicial Circuit and in Fort Lee County, Florida, criminal action, State of Florida versus Thomas Stein, case number 24 CF 000272, Rincon-Miller. If you found the defendant guilty of attempted robbery, you must then answer the following question. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant actually possessed a firearm? Yes, no. So say we all, again, a place for the date, four-person signature, and four-person to print their name. In the Circuit Court of the 20th Judicial Circuit and in Fort Lee County, Florida, criminal action, State of Florida versus Thomas Stein, case number 24 CF 000272. Special finding as to count 3, attempted robbery, Luann Deget. If you found the defendant guilty of attempted robbery, you must then answer the following question. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant actually possessed a firearm? Yes, no. So say we all, place for the date, for the four-person signature, and to print their name. In the Circuit Court of the 20th Judicial Circuit and in for Lee County, Florida, criminal action, State of Florida versus Thomas Stein. Case number 24 CF 000272. Special finding as to count 4, attempted robbery, Emma Wright. If you found the defendant guilty of attempted robbery, you must then answer the following question. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant actually possessed a firearm? Yes, no. So say we all. Again, place for the date, for the foreperson signature, and for the person to print their name. Single defendant, multiple counts. A separate crime is charged in each count of the information or indictment. And although they have been tried together, each crime, the evidence applicable to it, must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. Legally interlocking counts as to first-degree felony murder. Counts 1, 2, 3, and 4 are linked in that the crime charged in counts 2, 3, and 4, attempted robbery, is an essential element of the crime charged in count 1 as the first-degree felony murder. You should first consider the evidence applicable to count 2, attempted robbery, as to Kayla Rincon-Miller. You should then consider the evidence applicable to count 3, attempted robbery, as to Luann DeJay. You should then consider the evidence applicable to count 4, attempted robbery, as to Emma Wright. If you find the crime in count 2, 3, or 4, attempted robbery, has not been proven beyond a reasonable doubt, you must find the defendant not guilty on counts 1 as to first-degree felony murder. If, on the other hand, if you find the crime charged in count 2, attempted robbery, as to Kayla Rincon-Miller, count 3, attempted robbery, as to Luann DeJay, or count 4, attempted robbery, as to Emma Wright, has been proven beyond a reasonable doubt, you must then consider the evidence applicable to count 1, first-degree felony murder. A guilty verdict on count 2, attempted robbery, as to Kayla Rincon-Miller, count 3, attempted robbery, to Luann DeJay, or count 4, attempted robbery, as to Emma Wright, does not require a guilty verdict on count 1, first-degree felony murder. You should find the defendant guilty on count 1, first-degree felony murder, only if you find all the elements of that crime, including the essential elements contained in attempted robbery, as to Kayla Rincon-Miller, count 3, attempted robbery, as to Luann DeJay, or count 4, attempted robbery, as to Emma Wright, were proven beyond a reasonable doubt. Submitting case to jury. In just a few moments, you will be taken to the jury room by the court deputy or bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy or bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy or bailiff while you deliberate. If you need to communicate with me, send a note through the court deputy or bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items will receive the evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Most of these exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any exhibits not sent back into the jury room, please request that in writing. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. So with that, ladies and gentlemen, you can take your notebooks, and everyone except juror 77 and juror 29 may retire to begin your deliberations and take your notes. And juror 77 and 29, here's your name. You can get out and stand here, just don't forget. The record reflects jury says the court any objections to the instructions as read?
No.
All right. So you all are the alternate jurors. We don't tell people who the alternates are to the very end because we want everybody to pay equal attention. Your service is equally appreciated among everyone. Had someone had something come up and not be able to deliberate, you would be back there right now. It would be necessary for you. So again, we thank you again for your service. Leave your notebooks here. I'll destroy your notes. And if you have any belongings back there, we'll have Mike, when he comes out, he'll go back and you just tell him what you have back there. He'll get it and bring it out to you. You are excused for the remainder of the year for your jury service. And you have the right to either talk about your service or not talk about it. And so I'll leave that up to you. If you wish not to talk about your service and someone continues to ask you or is bothering you about that, tell a bailiff and I'll take care of it, okay, if you don't want to talk about it. All right? Just wait for a moment, let Mike come out and we'll get your stuff. And again, just leave your notepads here in the seats. You do have some things back there?
Yes, I do.
You do. You don't? When Mike comes back, let's switch you. All right, please be seated.
Can I take just a 2-minute Western break before we?
Just give me 1 second and let
Sure.
Mike come out and let's get them released and then you can. What's that? Leave your personal phone number for one of the girls. Oh, sure. Let me think. That's the first time I've been asked that question, so let me think about that for a minute. Yeah, if you want to leave it maybe for Mike, and at the end when they're excused, then he can give it to me. And Mike, they got some stuff back. You can tell Mike.
You have stuff in the back, just a black bag is sitting back in the back corner by the bulletin board on the floor. Where the what? By the bulletin board. Okay. And just that one case? Yeah, just the black. You
We're just gonna hold Mike, you're gonna hold on to that until after they're done. She obviously can't call you during deliberations.
Right, I know.
Okay.
Okay, let me get his black bag, and
Yeah.
if you would just leave your notebooks here in your bag, it's okay.
Yeah. All right, so is that, you all have everything you need? Are you going to escort them out in a different way?
I'm going to escort.
Okay, all right, thank you again for your service. And then Mike, I'm going to give you, or somebody, the instructions and the exhibits here in just a second. be in recess until we hear either, I would ask you to stay close in case there's a question or anything like that. And then just make sure that the clerk has your cell phone numbers to be able to call you back in if there's a question or anything. Don't go too far away. Okay? All right. We'll be in recess.
Well, all right, there we go. The jury finally gets to deliberate. That was the longest jury instructions I think I may have ever seen. And I've seen some, like multiple murder cases that took months. So that was quite something. That was just way too much to put on the jury. Way, way, way too much. Yeah, it was over an hour. It was 71 pages long. It was ridiculous. Why? Why does it have to be so? It doesn't have to be that detailed, really. It was crazy. I do have a new poll up. How long will the jury deliberate? Remember, you vote by putting in, and just put your number in a chat all by itself, not with other words, or I don't think it'll register it. So 1 is less than 2 hours, 2 is less than 4 hours, 3 is less than 6, and 4 is more than 6. I can't imagine we're going to go any longer than that. So give me your votes. Let's see what you think. But we are officially on jury watch. I will go check and see exactly what time the jury went back because, of course, we're behind a little bit. So that and then I'll zoom us up on the live so that we will see the verdict the same time that everybody else does. I think we'll get a verdict today. Do you all think we'll get a verdict today? It's let's see, what time is it? This is Eastern, so it is 3:22 there in Florida, in Cape Coral, where this trial is being held. So 3:22, they've already been at it probably at least an hour, and they could go till 6 or 7 even easily if they wanted to. You think we will? Yeah, I do too. Yeah, somebody said it's going to take them at least an hour just to go over those instructions and try to figure out what they mean, right? Yeah, if they're allowed to stay late, that's a good point there, Bethy, because it depends on, the judge. Sweet Relief says tomorrow morning. Okay. I think either way, we're very close at this point. So I'm just going to leave this live stream open as long as the jury watch stays open. I will be keeping an eye on updates and letting you know if something happens, or then we'll also be live if the jury comes back with any questions. And those, we'll see what happens. But I agree, Beth, it's not a real difficult decision. He was there. He was a part of the robbery. It is felony murder. It really is just the difference between first or second. I think that's really all the jury is going to spend any time on. I can't imagine that they really have any question that he was involved. He was not just naive and got manipulated. No, that is not what happened. I think we all know that. Thank you for being with me. I'll put up a new poll as soon as we know we've got a verdict. See what everybody thinks that verdict is going to be, but we'll keep the deliberation time poll up until then. So remember, you just vote by typing your number in the chat, 1 through 4. 1 is less than 2 hours, 2 is less than 4, 3 is less than 6, and 4 is more than 6. So I'll be here keeping an eye on things, and I'll jump in if I learn any updates. All right. So thank you for joining me, and we'll talk soon.
Is the state nearby or the other ones? Okay. Yeah. Just touch base. See what happens.
Yeah, do you want them to come back?
Yeah. It's going straight to voicemail for me.
Okay. Hey, you guys want you guys to come back before
back on the record with the state of Florida versus Thomas Stein, case number 24 CF 272. Put the state defense counsel and the defendant are present. I came out just to check in with you all and see about checking in with the jurors. It is now almost 5:40. What I intended to do was to have the jurors come out, let them know they're under no time limit in terms of their deliberations, but find out from them if they want us to order dinner for them so they can continue their deliberations this evening, or come back tomorrow morning and continue their deliberations and go home for their dinner and spend the night at home. Any thoughts from the state of defense?
Judge, if I may,
Yeah.
I would object to that procedure. I found in the past that, telling someone, hey, listen, we're gonna send you back with some dinner, makes them rush to judgment. There's a propensity for that.
I'm sorry, say that again?
There's a propensity for them to rush to judgment and kind of rush to their deliberations.
By ordering them dinner?
Right, Judge. To see if they're gonna be done, if they want to come back tomorrow.
Okay.
If we're inclined to let them go home, I would say, let's just pull them up, send them home, tell them they're coming back tomorrow.
Oh, okay. I understand what you're saying.
My question would be, I feel like this has been done before, I don't know if it's been done in your courtroom, is just to send a note that if they want to order dinner, they can order dinner, and then that way there's no pressure. If they want to order dinner, they can. If they don't, they don't
Right.
have to. But I think
And the reason I came out now, I came out at 5:30 is because it does take 45 minutes to an hour so to get the dinner here. It's pizza, but it does take some time to get here. So
that's what I would
I've
request.
just sent a note. I'm aware of just sending a note back there to see if they want to order dinner.
Yeah.
Any objection to that?
Judge, I would ask that we just pull them up and have them come back tomorrow.
I don't.
Well, I don't know that that's necessary at this point.
It's Edwin says.
I mean, I'm not suggesting anything by saying would they like us to order dinner.
Well, I mean, the court's instructed the defense to kind of stay at the courthouse until, there's end for the day, so.
I'm sorry, say that again?
The court's instructed the defense to stay in the courthouse, to stay nearby.
Stay nearby, yeah. You don't have to stay in the courthouse, but,
No.
well, you do now because it's after 5, so to get back in. Well, I mean, if the choices are, let's see, just bring them out and tell them I'm sending them home, which I don't know if that's appropriate at this time. Or asking them if they want to order dinner by just sending a note if they want to order dinner. Or I could just order dinner now and then see where they are in about an hour without even saying anything to them. Or bringing them out and asking them what option they would want to do. I guess the first option and the third option involve talking to them and interrupting their deliberations. The second option, which is just going ahead and ordering the dinner for them and then just sending it back there at some time after it gets here, which would be probably sometime after 6 if they're still deliberating.
What time does the court typically work till, Judge?
It depends on the jurors. We have sent jurors home. If they wanted to go home, we've kept them here, and then they have deliberated until, later into the evening. So there's no set rule on that. So,
The state's preference would just to send a note that if they want to order dinner, we can do that. I don't think there's any reasons to interrupt the deliberations and bring them out and talk to them, because I think that could put pressure on them to make a decision.
Right.
And it's also not, they've only been deliberating since
3:20 something.
3:20, so that's not a long time given the charges. It's
Sure.
not late in the night. We're not even at 6 o'clock, so.
Okay. Understand that. Anything else, Mr. Wheeler?
That's right.
What I'll do is I'm just going to go ahead, Eric, just order the dinner, and then I won't say anything to them, and then it'll be here in about an hour or so, and then, if they're still deliberating at that point, we just send it back. All right? Is that all right? That way I'm not interfering with them.
That's fine, Judge.
They'll send us a note if they want to continue into the evening or come back tomorrow. We'll just leave it up to them. Is that all right?
Yeah.
Okay. All right, then. We'll be in recess until further notice. And again, you can, I want you to stay close. I know you go to your office next door, but it was only about 10 minutes to get over here. I mean, if you can figure out a way so that you can stay close, but, I mean, I obviously don't mind if you guys go out and have something to eat or something like that, but just be, wherever we call you, and get over here within, reasonable amount of time, close to the 10 minutes. Is that all right? And then, is there a way for the attorneys to get back in, go talk to the bailiffs?
I think let me English then.
Okay, thank you. We're in recess. Please be seated. Yeah. You were able to contact me? All right, let the record reflect that the state's present defense counsel and the defendant are present or back on the record of the case of State of Florida versus Thomas Stein, case number 24 CF 272. We have a question from the jurors. I'll read it aloud. It says, 2 jury members need to call pet sitters. So, what I'll do is, unless there's any objection, I'm going to call them out, find out which jurors need to make that call for pet sitters. Has the pizza already been sent back to them? Yes, sir. So they've been delivered the pizza already, and then we'll just go from there. But I'm going to let the jurors use their phone here in court to call the pet sitters, and then they leave their phones in here and go back. If they ask about wanting to come back tomorrow, I'm going to tell them yes, they can come back tomorrow. But I'm not going to imply one way or another what they need to do. Is that any objection to that?
No, from the defense judge.
No, I just was gonna suggest that the 2 people who even call the pet sitters come out without bringing them all out, but rather than bring all the jurors out.
Well, I don't know who it is.
I mean, yeah, I guess.
So let's just bring them all out. I'll read the note out loud, just like the standard thing, make sure that's what they asked, and then we'll answer that question. You're going to have those phones available to figure out which 2 need their phones.
Yeah, I don't even know.
Okay. You can bring them out. Please be seated. Ladies and gentlemen, the jury have received the following question. It says, 2 jury members need to call pet sitters. If I have not read the note correctly, please raise your hand. Seeing no hands, we need to know which 2 members need to call their pet sitters, okay? And then we can allow you to pick out your phone. We just have you call them here in open court, and then we can do that.
You want us to come down there, or we just?
No, you can go right there.
Okay.
Let's go. And it's
337.
juror 337 and 424.
424. Do you need it on speakerphone?
No.
Okay, I'll call first.
Hey, I'm in open court right now, so would you mind, probably if I can be here for a little bit longer, maybe would you mind taking care of Bella again? All right, we're gonna be here for a while. All right? Thank you. Whenever, between now and 8 o'clock. All right, thanks. Bye.
Hey there, just wanted to make sure that you were taken care of, the agenda was taken care of. Okay, okay, we're still deliberating, and I'm just, I've got to get off here, I just wanted to check in with you real quick. Okay, 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 thanks, bye-bye.
All right.
Thank you, Your Honor.
You're welcome. All right. We got all the phones back. I'll send you back to the jury.
Thank you.
All right. Let the record reflect the jury's thanks to the courtroom. Any objections to the jurors calling their pet sitters?
Not
No, no.
to say that.
Thank you. We'll be recessed until further notification from the jury.
We'll come to order, all rise.
It's all right. Please be seated. All right, the record will reflect the state's defense counsel and the defendant are present. My understanding is, from Bill, that the jury has reached a verdict.
Yes, sir.
Are both the state and defense ready to receive the verdict?
The state is
We are.
All right. You can be seated and bring the jury in, and he knocks Walston. And let me just say that, Mike, I'll say it briefly. Remember my earlier instructions. There's rules of decorum in court. I expect no reaction whatsoever. I don't want any type of reaction. I know it's an emotional case, but there should be nothing that interferes with the jury's work or causes them to feel any type of influence from a reaction from the audience. So if you can't control your emotions, please go out in the hallway. And so you're ordered not to have any expressions of emotion or anything in the courtroom, okay?
Yours and right.
All right, please be seated. Ladies and gentlemen, the jury have been informed you have reached a verdict. Is that correct?
Yes.
Is juror 337, are you the foreperson?
I am.
If you pass the verdict, form to the debate.
Sure, thank you.
All right, the court finds that the verdict form has been filled out and dated and signed by the foreperson. I will give it to the clerk to publish the verdict.
In the Circuit Court of the 20th Judicial Circuit in Lee County, Florida, criminal action. State of Florida versus Thomas Stein, case number 24 CF 000272. Verdict. We, the jury, finds as follows as to the defendant in this case. Count 1, first-degree felony murder. The defendant is guilty of first-degree felony murder. Count 2, attempted robbery. Kayla Rincon-Miller. The defendant is guilty of attempted robbery with a firearm. Count 3, attempted robbery. Louis DeJay. The defendant is guilty of attempted robbery with a firearm. Count 4, attempted robbery. Emma Wright. The defendant is guilty of attempted robbery with a firearm. So say we all, dated May 4th, 2026, foreperson. In the Circuit Court of the 20th Judicial Circuit, Lee County, Florida, criminal action. State of Florida versus Thomas Stein. Case number 24 CF 000272. Special findings as to first-degree felony murder. If you found the defendant guilty of first-degree felony murder, you must then answer the following questions. Do you unanimously find beyond reasonable doubt that the defendant actually killed, intended to kill, or attempted to kill Kayla Christina Rincon-Miller? No. Do you unanimously find beyond reasonable doubt that during the commission of the crime, the defendant personally carried, displayed, or used a firearm? Yes. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant actually possessed a firearm? Yes. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant discharged a firearm? No. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant discharged a firearm and in doing so caused the death of Kayla Christina Rincon-Miller? No. So say we all, dated May 4th, 2026, foreperson. In the Circuit Court of the 20th Judicial Circuit in Worley County, Florida, criminal action. State of Florida versus Thomas Stein. Case number 24 CF 000272. Special findings as to count 2, attempted robbery, Kayla Christina Rincon-Miller. If you found the defendant guilty of attempted robbery, you must then answer the following question. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant actually possessed a firearm? Yes. So say we all, dated May 4th, 2026, foreperson. In the Circuit Court of the 20th Judicial Circuit in Worley County, Florida, criminal action, State of Florida versus Thomas Stein. Case number 24 CF 000272. Special findings as to count 3, attempted robbery, Louis Dejay. If you found the defendant guilty of attempted robbery, you must then answer the following questions. Do you unanimously find beyond reasonable doubt that during the commission of the crime, the defendant actually possessed a firearm? Yes. So say we all, dated May 4th, 2026, foreperson. In the Circuit Court of the 20th Judicial Circuit in Worley County, Florida, criminal action, State of Florida versus Thomas Stein. Case number 24 CF 000272. Special findings as to count 4, attempted robbery, Emma Wright. If you found the defendant guilty of attempted robbery, you must then answer the following question. Do you unanimously find beyond reasonable doubt that during the commission of the crime, the defendant actually possessed a firearm? Yes. So say we all, dated May 4th, 2026, foreperson.
Does either party wish to have the jury polled?
Yes.
All right.
Juror number 301, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 225, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 424, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 539, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 291, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 559, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 348, is this your verdict and the verdict of the jury as a whole? Juror 92, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 231, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 337, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 3, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 160, Is this your verdict and the verdict of the jury as a whole?
Juror 160.
Yes.
All right. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. With that, again, we thank you for your service. We'll make sure we get your cell phones, all of your electronic devices, and all the anything you have back in the jury room. With that, you'll be excused and go with the bit. Let's make sure we get all the notepads this time back. Let the record reflect that the jury has exited the courtroom. Please be seated. All right, Mr. Stein, the jury having convicted you of count 1, first-degree felony murder as charged, count 2, attempted robbery as charged, attempted robbery with a firearm, count 3, attempted robbery with a firearm, and count 4, attempted robbery with a firearm. To those charges and as to the special findings, which they did find it beyond reasonable doubt that during the commission of the crime, you personally carried, displayed, or used a firearm, and that you did actually possess a firearm. And that's as to the first-degree felony murder charge, as well as special finding that you, as to count 3, attempted robbery, that the jury found beyond reasonable doubt that during the commission of the crime, you actually possessed a firearm. And as to count 4, attempted robbery, again, that you did actually possess a firearm during the commission of the crime. And as to count 2, attempted robbery, that the jury did find beyond reasonable doubt that you, during the commission of the crime, you actually possessed a firearm. So as to those charges and those special findings, I adjudicate you guilty. What says the state in regards to sentencing?
Judge, he will be entitled to a PSI. Also, I know there's certain sentencing factors that the defense may present, so I defer to them as far as how far they want sentencing out. It would need to be at least 30 days, I think, for the PSI, but as far as the sentencing factors, I don't know if there's other.
Very well, Mr. Wheeler.
Judge, I'm looking at July. I'm asking the court for 60 days at least.
Okay. Just take a look. How about Monday, July 20th at 1:30.
Judge, I'm out of the office that week, for my vacation. How about July 10th?
I think that week you said July 10th. That way I have a date certain trial that week, so I won't be able to do it that week. How about are you out the entire week of the 20th?
Yes, sir. How about the 31st?
I'm sorry?
31st of January.
Let's see. I can do Monday, August 3rd at 1:30.
I'm out that week.
Okay. There's date certificates that isn't supposed to be on the, sorry. On the- How long do you plan on for sentencing? Like how much time should I block?
I would say at least a couple hours, Judge.
What's that?
Probably 3 hours between the two of us.
How about, you're not there on the 17th, right? Or are you? That's before you get.
That's fine, Judge.
Are you available July 17th?
Yes, yes, Judge.
All right. I'm going to set it for Friday, July 17th at 9 a.m. I have a date certain trial tentatively scheduled with state certain, but things change between now and then. So if that ends up having to still be taking place, we'll contact you all well ahead of time to readjust that. Okay? So July 17th at 9 a.m.
And Judge, Ms. Wolf just reminded me, I haven't done this a lot, but there also needs to be a PDR ordered because he was a juvenile. And then if you can just give an order allowing DJJ to have access to him in custody, I know that can be an issue.
Okay, so I'll order a pre-sentence investigation, predisposition report, and I'll allow DJJ to have access to Mr. Stein while he's in custody. let me ask you this. Are y'all available on July 10th, that Friday, the Friday before?
Yes, Judge. July 10th.
July 10th?
Yes, sir.
You are? Okay, so,
Mind your own business.
That's it.
We'll set this then for July 10th at 9 a.m. And I made those orders. Mr. Stein will be held without bond until sentencing, and you'll be fingerprinted and remanded at this time. Anything else before the court?
No, thank you.
Anything from the defense? All right, thank you.
You probably already have another court date. You can check with them still, and even though you have a private, they'll tell you the court date. With the two ladies in the side of the
My tan.
I don't see his name here. So that means he's probably represented. We're not gonna call this case.
Court will come to order, all rise. Circuit Court in Fulton County is now in session. Now will judge and the counsel presiding.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Good morning. Please be seated. All right, are we ready for arraignments?
Yes, Your Honor.
All right.
Starting with Judge Branning's docket, Dersu da Silva, 26 CF 000173. You can come up.
You applied for the public defender today and qualifies, Your Honor.
All right, public defender's appointed.
This is for De Silva?
Yes.
Yes, Your Honor, we'll just enter a plea of not guilty, waive the formal reading of the charges, ask for a CMC.
All right.
And state filing information.
What's the next court date?
June 9th at 8:30 a.m. and 8B.
Did you get that? Did y'all hear your court date?
What was it again? Sorry, he was
June.
saying he needs a Brazilian Portuguese interpreter.
I don't know if we have one today.
I know, that's why I just
Okay.
wanted to know his next